All right, thank you. All right, bye. Volume control. Off that box in the back, right? I tell whoever's going to be.
What was that? Okay. Good morning.
Good morning.
Can I get a sound check 1 through 10, please?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. I may be putting headphones. I'm gonna put headphones on. Is that okay? Or
That is all right. Yep.
hang on 1 second. There's gonna be some noise where I'm at.
Sure.
So, I don't want them yelling at me. I did it right. Okay, backwards. It's fine. They fit funny. Good morning. Can you hear me?
Yes, I can hear you just fine.
That's even better. Look at that.
All righty.
Just so, am I the first one here?
No. But from, I believe you might have just heard, but in case you didn't, the audio is coming out of the smart board in the courtroom a little low. So when it's time for you to speak, just try and project your voice a bit.
Took it upon yourself.
So just curiously, are we just gonna have to know our order since there's so many of us, or is someone going to say next speaker?
The chief will introduce the next speaker, and then we will promote you accordingly.
And so you want us to pin that view, correct?
Yes, it would be best for you to pin the FLSC conference, the one that is the video going into the courtroom. Pinning that would be ideal for you.
I just pinned it, and I remember when we did our walkthrough, it was hard to see Judge Grosshand's chair
Testing 1
on the video.
Yeah, she's the far right,
Yeah.
where Devin is pointing. That is her
Okay.
chair.
Okay.
Testing 1 2.
Ready?
Just remember, we couldn't see it when we did the video through.
Yeah, we did some additional testing after.
Testing
Sure.
1 2 1 2.
Okay. All right.
Testing 1
I'm
2.
gonna demote you down to attendee, and then when it's your time to speak, I'll promote you again to
Testing
panelist.
1.
And yeah.
Okay.
Okay.
Testing 1 2. Testing 1 2 3 4 5 6 7 8 9 10.
I can hear what you're saying, but you do sound far away.
Testing 1 2 3 4 5 6 7 8 9 10 11 12 13 14 15 16 17 18 19 20.
I can hear the numbers you're saying, but the audio quality is not the best.
Yeah, y'all hold up for a minute. One, two, three, 4, 5, 6, 7, 8, 9, 10, 11, 12.
That sounded good.
That's better. Okay.
You put that this low?
Wondering if somebody was gonna notice it. Oh, no. Yeah.
That's,
I always do it because nobody touches it.
someone say, Kurt?
Well, we're already on the external, so you're not needed. Yeah. Yeah. Yeah, we should be good
Missing Lauren Rowe. Is she, oh, administration? So on the other side of the rotunda, there's going to be on the right. There's like a ramp that goes up. It'll be there. You're welcome. Hey, Devin. Would you mind confirming something in Teams real quick? Okay.
Good morning, panelists. Can everyone hear me okay?
Morning.
Yes.
Good.
Morning.
John Tomasino this morning. Thank you for participating in our first hybrid OA. Hopefully everything will go smooth. I know Devin and Brian and the WFSU team has been hard at work to make sure that this is smooth. One thing I wanted to point out, in past cases when it was completely remote, we would be elevating and demoting the speakers when it was their time to talk. But with this case, since we're going to be, you got this hybrid model, instead, we're just going to, from when the case starts until the case ends, all of you will be showing on the screen in the courtroom, kind of in this nice grid pattern. Most importantly is remaining on mute until it is your time to speak. Our staff can also mute you in case somebody forgets or something happens, but ideally you handle the muting and unmuting. But I just want to make sure that you're aware that for the entirety of this argument, you will be on the screen, viewable by those in the courtroom and watching the broadcast channels and whatnot. When it is your turn to speak, once the five of y'all, I believe we've got you, and thank you for agreeing to the slight reorganization. Once we move to the virtual participants, then our staff will be spotlighting the video of whoever is up at that time so that your screen window, video window is nice and big and filling up the whole screen in the courtroom. Once the fifth person speaks, I'm trying to remember who is fifth, possibly Alan. Yeah. Once Alan is done, then we'll change you back to the grid view so that all of you can be seen. In case the court has a question, who knows, but just want to make sure you know we're leaving you showing the entire time. So don't think that you're off camera, because you will. You want to avoid any potential embarrassing pause. So does anyone have any questions? Everybody looks great. You got positioned well. Remember too, WFSU is going to put graphics on the screen that take up about the bottom quarter. So you definitely want to kind of have your head toward the top of the screen if you don't want the graphics to kind of obscure your mouth. And other than that, everybody does look good. The backgrounds look good. So thus far, I think all signs are pointing to success, I hope. Does anyone have any questions before I don my jacket and get to the courtroom?
I have one question. It looks like then Sandy Solomon is not appearing. Is that right?
I haven't even checked what Chris, our OA clerk, provided.
On the sheet that's on the website, I was supposed to go after Sandy. I was supposed to be second, but I don't see Sandy in the screen here. So
yeah, give me 1 second. I'll get an answer on that. Let's see.
And I thought Sandy was appearing in person. Is that not the
Yes.
case?
oh, okay.
Yeah, so what I see is Judge
Understood.
Munyon first, Judge Orfinger second, and Sandy Solomon third, and that's all live. And then Jason.
So I'm the first virtual. That was my
Yeah.
mistake. I thought I was the second virtual participant. So that's what threw me off. I understand.
Yeah, I believe we have Jason, and then I moved it onto a screen that I can't see. So let me move it back here. So the way we have it is Jason, then Laura, then Anthony, then and then Alan.
It's Mia.
Mia, thank you, Mia. Thank you.
Thank you. Thank you.
I should have said Miss Tell, but at least I know. So thank you.
And just to be clear, John, all that you're saying, when it's our turn to speak, the chief will say, next or something along those lines, and we'll unmute, and then one of your staff will go ahead and pen us so that we're up on the smart board in the courtroom, right?
Well, you'll be on the smart board the entire time in this grid view. And then when the chief switches or calls Miss Rowe, you may now, then we're just going to make it so that your screen, your video will take up the whole smart board, and we'll go out of the Hollywood Squares view or Brady Bunch view and instead to full speaker view. But you don't need to worry about that. We'll just be handling that behind the scenes.
And would you like us to leave our video active the entire argument?
I think so. Yeah, I
Okay.
think, I mean, unless something, unless the weatherman's child comes in behind you or, anything. But I think this will make it as close to live as possible. I think if y'all can, I'm glad you asked and I didn't specify that. So thank you, Laura. Yeah, I think if you can, just leave the video on and the mic muted until it's your time to speak.
Okay, thank you.
And we have looks like, go ahead, Devin. Right, but until they talk, and Judge Munyon and Sandy Solomon, what will the view be when none of the remote folks are talking? Okay, do you have any? Okay, gotcha. All right, so scratch that. I'm not exactly sure. It sounds like we'll have a graphic, pretty graphic on until it's time for you to speak. And then Devin, you're going to go back to the graphic after Alan? Okay. All righty. If that changes, we will let you know. So we'll chat or somehow we will let you know if that changes. So my apologies on that. I thought I had that straight before I called in. So good to know.
I have a quick question. Did anyone hear the noise that's in my background? Nope. Okay, good. I'm gonna keep the headphones on. Sorry. Yeah, I don't have a walking person, but I have people.
Yeah. If I was doing this, there's absolutely no way I would make it through without a dog barking at some point.
Well, that would just happen, a very large dog barking, and I could hear him, but I was hoping you guys could not.
We did not. Must have done a good noise suppression on you, but you have my sympathy on that one. I know that experience very well. So, all right, well, we're getting close. So I hope everyone has, we're looking forward to this, getting this COVID-19 one worked out. And thank you everyone for your participation on it. Appreciate it. Hope it goes smooth. Thank you.
Justice, may it please the court, Anthony Musto on behalf of the Civil Legal Aid Association, which is a group made up of the executive directors of all the major legal aid providers in this state.
Tony, you're not
Yes.
on mute.
Oh, I'm sorry.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All we have cause to plead, draw near. Give attention, and you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning. Welcome to this session of the Florida Supreme Court. The first case on our docket is in re amendments to the Florida Rules of Civil Procedure, etc. A lot of procedural rules are in this rules case. And we, before we get started, and I recognize Judge Munyon, I want to thank everyone who has participated in submitting comments for this rules case. I also want to thank the work group that put together the package and responded to the comments, and particularly thank Judge Munyon for her leadership. This is it's a complicated subject, and it's an important subject. I would ask, as we go through this, that we've got an hour. If we need a little more, we'll take a little more. But that everyone try to focus on kind of the most recent version of what we're talking about here, which are is the version that the work group has come back with in response to comments. Because I think some of the concerns have been addressed in that. And of course, you can say whatever you want to and focus on whatever you want to, but I think it would be more productive use of time to focus on that rather than kind of his history of how it developed, except to the extent that that is relevant to some remaining concern you have. But with that, I want to recognize Judge Munyon.
Thank you, if it please the court. Chief Justice Kennedy, Justices, good morning. Thank you for the opportunity to address you this morning. My co-petitioner and I would request 8 minutes in rebuttal. I will take 10 minutes of the petitioner's time in this initial argument, and Judge Orfinger will take 5. Because of the limited time and the many areas covered by this rule, if it please the court, I will begin with a very brief overview of how the work group structured the proposed rules. I will then concentrate on areas that seem to be most in controversy. The petition spans 7 rule sets and 26 rules. Many are technical or conforming changes because of the change in terminology, but there are substantive changes in these rules. In proposing changes to the rules of general practice and judicial administration, we strive to keep this rule set as rules of general application. If particular case types needed exemptions from the general rules and the RGPJA, we encourage those exemptions or exceptions to be codified in the applicable rule sets. We considered the comments very carefully and tried to make adjustments to the proposals to address the concerns expressed where we could do so and maintain the fidelity of the rules that we were proposing. I will be the first to acknowledge that these rules aren't perfect. The work group did the best it could with this complicated subject. And I would like to thank State Court Administrator Ali Sackett and the Office of State Court Administration for all of their hard work in assisting the work group in coming up with the petition and these rule changes. The first area of controversy deals with how these rules impact self-represented litigants. The work group recommended that Rule 2.516B1C and D be amended to require self-represented litigants to designate a primary email address for service by electronic mail unless the SRL declares under penalty of perjury that they're in custody, do not have an email account, or do not have regular access to the internet. 3 forms were created, one form to request to be excused from email service that provides for the clerk to ministerially determine if the SRL has filled out the form correctly and is therefore excused from email service. And the form also provides for judicial review if the self-represented litigant disagrees with the clerk's determination. One of the forms is to designate the email address, and one form for changing a physical or an email address. Opposition has been raised by groups representing self-represented litigants. They argue that the proposals would violate an SRL's right to access to the courts, place SRLs without regular access to the internet at a disadvantage to those with immediate access, that e-service should be opt-in, not opt-out, and will expose self-represented litigants and lawyers to greater cybersecurity risks, will increase defaults and dismissals, will delegate judicial duties to the clerk. The work group made changes and provided forms based on their feedback. However, the work group does disagree with many of the comments on this issue. Because a straightforward process is provided for self-represented litigants to request to be excused from email service, there is no access.
Judge Mannion, could I ask a quick question?
Yes.
Based on your long and exceptional service on the Florida Courts Technology Commission, where you and the other group of folks that serve faithfully there look at the security of our records and our systems, do you think that there is a legitimate concern about security from this?
There is not a legitimate concern about security.
Thank you.
The e-portal recently passed its 10th anniversary. There are more than 350,000 accounts at the portal, and of those, more than 243,000 accounts are self-represented litigants. If there were security concerns, we would know it by now. It would have shown up in the last 10 years. I will tell you that while email service as proposed does not place self-represented litigants without regular access to the internet at a disadvantage over their present status quo, SRLs who do not have email service are presently at a disadvantage to other litigants on the same case who receive e-service. Many times the self-represented litigants don't get e-service, not because they don't have access to an email address or the internet, but because they lack the knowledge about how to sign up for an account at the e-portal. This proposal goes a long way toward leveling that playing field. So I would encourage the court, if you see fit, to require SRLs to provide an email address or fill out one of the forms indicating why they could not provide an email address. It will assist them in getting court documents much more quickly and will not require them at this stage to e-file through the portal. One of the other rules that affects self-represented litigants is Rule 2.530. We have recommended that that rule be amended to allow virtual, non-evidentiary, and evidentiary hearings, even over the objection of a party. Right now, Rule 2.530 requires testimony that is taken via electronic communication to be only permitted upon stipulation by both parties. The self-represented litigant community has argued that if a self-represented litigant does not have regular access to the internet, they should be per se excused, or it should be per se good cause for not having a virtual hearing in a case, whether it be non-evidentiary or evidentiary. I believe this would be short-sighted. Right now, many courts, as this court is doing today, have hybrid hearings. And if a self-represented litigant doesn't have regular email access and wants to go to court, an objection by them, if the proposal is accepted that has been that has been advanced by the self-represented litigant community. If that proposal is accepted, hybrid hearings would be a thing of the past. If one person objects, then everybody has to come to court. Well, if a self-represented litigant in a hybrid hearing wants to come to court and hear what's going on and be there in person, that's great. But it should not stop others who can effectively participate virtually from participating virtually. I would also let the court know, as I'm sure you already know, many courts, we've had to be very creative during the pandemic. And many courts have set up kiosks when we could not have essential hearings in person to allow those without internet access or without equipment or without the skills to participate in non-essential proceedings virtually by coming to the courthouse and being in a safe room by themselves where they can participate via electronic equipment.
May I ask you one
Absolutely.
question? A few years back, in Doe v. State, I think it was 2017, we dealt with Baker Act proceedings.
I was going to get to that one.
And you were?
I'm
you want me
going to get to Doe. That is the
Well-
big controversy as well, I
Well,
think.
why don't I do this? Why don't I just let you follow your script, and when we get to it, we'll talk about it.
All right. Well, that was actually, I was finished with that part, and I will turn to Doe.
Judge Mannion, before you leave,
Yes.
can I just have some technical questions about 2.530 that don't really address the pro se or self-represented parties, but is it kind of the understanding that a party would be required to file a motion for virtual hearing? Let's say we have two attorneys, so we'll go there. Two attorneys for every single hearing that they wanted virtual, or would this be something that would be filed at the beginning and apply throughout the case?
I don't know if we considered that, quite frankly. I think the rule as proposed envisions that the motion or notice of hearing indicate that it is in fact virtual. That would give a party the right to object to that particular hearing being virtual, but it is quite frankly something that I don't recall being discussed.
And then is this something that, let's say, you have, it just seems, was there any talk that based on the past 2 years, that when you had two represented parties, again, two attorneys, not dealing with the self-represented, which is a whole nother issue, that the automatic would be virtual, and then that there would be an opt-out on good cause? It just seems like in this, based on how many, we got a lot of case management things happening now, we have a lot of motions, we have a lot of motion practice. If for every single one, this is an attorney has to file something, let's say they're working with difficult co-counsel who wants to object every time. Does this mean the court has to have a hearing each time just on the request for virtual? Would this be something decided in chambers? I mean, was any of that kind of part of the discussion of what that would play out like between attorneys on that issue?
The presumption under the proposed rules is that if the hearing is 30 minutes or less and non-evidentiary, that virtual would be permitted. Other questions before I move to Baker Acts and Doe? In the petition, the work group did ask the court to revisit Doe versus State as part of implementing the changes to Rule 2.530. I can tell you it gives me a bit of angst to be up here asking the court to revisit something like that in a rules petition. However, Bakers and Marchmans do not have their own rule set. We did not carve out an exception in Rule 2.530 to Baker and Marchman Act proceedings, and we wanted the court to be aware of that. I believe that there are good reasons for the court to revisit Baker and Doe versus State and the physical presence of the judge and Baker and Marchman Act hearings. I will tell you that the facts in Doe are pretty brief, and so it is difficult to glean exactly what happened in Doe, but it appears that the judge and magistrate in Doe that were hearing cases in one county in the southwest part of the state sent an email to all participants with very short notice that all hearings would be virtual from now on. All of the participants would be at the facility and the judge would be elsewhere. There was no opportunity to be heard, no provision for objecting to the judge's decision that the hearings would be virtual. And so writs were filed, I believe, in the second DCA and eventually made it up to this court, in which the respondents argued that they had a substantive right to have the judge present in court with them. Much of Doe relies upon a 1999 report that came out of a work group that was part of the Commission on Fairness that was instituted by this court. Many of those recommendations in that 1999 report have never been realized. And a lot has happened in the technology arena over the past 23 years. So that technology now is very different than technology was in 1999. The accessibility to technology now is very different. There have been many technical advances that permit hybrid hearings. Now, I will tell the court, I'm trying to keep track of my time, that I only have 10 minutes. Many technical...
You've got about 6 minutes remaining.
Oh, okay.
You're actually, I think, moving into your rebuttal at this point. So.
Oh, I am moving into my rebuttal.
Yeah.
All right.
I mean, you're well into it, actually.
All right. Then I am going to stop here and answer any questions you have. And Justice LaVarga, did you have any questions?
So when we considered Doe, that was back in 2017, long before this pandemic came around, and we started using Zoom and all these technology, and things seem to be a lot better now. Like you said, technology has come a long way, and I'm just wondering if your comfort level is there with dealing with declaring somebody, Baker acting somebody through a television set.
It will depend upon the facility and the technology available at the facility. If the facility has a laptop that they pass around from one person to the next, would I feel comfortable with that? No. But if it is a courtroom type setting where I could see everyone can see everyone else, then it might be acceptable. But I think we have to take it slowly, and it has to be on a facility by facility basis.
Would it have to be something that substantial? That pointing to the
Would I
screen?
like that?
Yeah.
I would absolutely like that. Would it be required? Maybe not. But I believe these rules provide a very robust framework for making a decision about whether a virtual appearance is in the interest of justice.
Thank you.
Thank you.
May it please the court. Chief Justice Kennedy, your honors. I'm Michael Orfinger. I'm the chair of the Alternative Dispute Resolution Rules and Policy Committee, and I'm here this morning to speak in favor of the work group's proposed amendments to Florida Rules of Civil Procedure 1.700, 720, 750, 730, if I forgot that one, and Rule 1.830, as well as Rules of Appellate Procedure 9.700, 720, 740. They all deal with the use of communication technology in mediation and arbitration at the trial and the appellate level, and the amendments use the proposed definition of communication technology in the proposed amendment to Rule of General Practice and Judicial Administration 2.530. Some of the proposed amendments were not changed in the response, so you can find the original version in Appendix A to the original petition, and the ones that were revised are in response to comments are at pages 1 through 13 of Exhibit A or Appendix A to the work group's response. To a large extent, the revised rules are intended to memorialize what's been happening in ADR during the pandemic, with necessity being the mother of invention. As a general matter, the amendments are intended to allow virtual ADR to continue beyond the pandemic and to give the parties the maximum flexibility to decide that initial process issue, that initial shape of the table issue of whether mediation or voluntary binding arbitration will be conducted in person or via communication technology, or as we are doing today, with a combination of the two. The two key rules would be Rule 1.700A and Rule 9.700B. The first deals with circuit and county court mediation and arbitration, the second with appellate mediation. And both of those rules make appearance in person the default, unless the parties stipulate to use remote technology or a combination, or unless the court orders, even over party objection, that the proceedings be conducted with communication technology or in that hybrid combination. Now, the rules are structured so that the court can retain control over the method of appearance if it chooses to do so. There may be difficult clients, and the trial court has experienced prior proceedings and sees that, hey, they need to be together. They need to be in person. They need to experience the discomfort of an in-person dispute, just like they would experience the discomfort of a trial. There may be safety concerns which warrant remote appearance in ADR. But it also recognizes, or both of these rules recognize, that ADR is going to be less formal than a trial, less formal than an appearance before a court of appeal, and that there's a benefit to giving the parties control over the process. And I think that's especially true in mediation, because if they can control the process, since they also control the outcome, they're more likely to be willing to settle. And there's some at least anecdotal evidence in from the Civil Procedure Committee in the survey that the ADR committee section of the bar in the survey that they conducted, and that's in their response. There's also a somewhat similar provision in Rule 1.830A2 for voluntary binding arbitration, which would allow the parties to decide on the procedures to be used, including whether communication technology would be used. And if the parties don't reach an agreement one way or the other, then the referring court establishes those procedures. Also rules...
I did not warn Judge Munyon that she moved into her rebuttal, but I will warn you, you're now into your rebuttal time.
And she speaks more quickly than I do, so unless you have any questions about what I've covered thus far, I will reserve my remaining time. Thank you, Your Honors.
Thank you.
May it please the Court, Chief Justice Kennedy and Justices, my name is Sandy Solomon. I have the honor of being the chair of the Rules of General Practice and Judicial Administration Committee. We stand here in support of Judge Munyon's work group virtually on all of the issues. As Justice Kennedy pointed out, the revision in November adopts many of the changes that we had suggested. We've been working on this rule for about 3.5 years, this rule being 2.530 in particular. It is complex, and the question that Justice Groshans, if I pronounced it correctly, has raised was a matter of debate in our committee at great length, and it really boils down to whether or not the issue is to be presented by motion or by informal request. And there was a split among the committee. We decided that by a slim majority, that the determination of how a non-evidentiary proceeding and an evidentiary proceeding would be handled would be addressed by a motion with a formal objection procedure. In Justice Munyon's explanation of that as to why the objection procedure was necessary was to assist people who were SRLs or otherwise had difficulty in accessing the system. And we adopted that by a majority, but there was still this undercurrent of how many times do you have to ask the trial judge what constitutes an emergency, which division of the court are you in, whether it's a family law case that has emergency motions filed by the bucket load every day that some duty judge has to address, and that's a very difficult process. So we thought that the balance between the motion process and the discretion afforded to the judge or to the court official was sufficient to dilute any inconvenience that was associated with that. But it is an issue, and it is an issue that we thought should be addressed in gradations, but that was basically rejected because of the SRL issue and because of the need for a formal objection. Let me digress. I wanted to address that issue first off because I think that was one of the key issues that we confronted and on which we had a substantial divergence of opinion. But we have been working, and I presented to this court about 5 years ago a set of rules that would have allowed the rules of general practice and judicial administration to be dubbed the rules of general and common application, and to be broadened across all of the rule sets. We have not 7 rule sets, we really have 11 rule sets, and all of them have commonalities because they all go to the courthouse and they all have judges or court officials attending to them. We had such pushback from the various rules committees thinking that who died and left the rules of general practice the boss after everything was done. And what we did was we provided for a carve-out. And each of the rules that we have provided says something to the effect of, unless governed by another rule set. And Judge Munyon's description of why we don't need a double carve-out for criminal or a double carve-out for juvenile or a double carve-out for civil commitment convinced us that that was the way to go. We have the structure of the rule substantially changed between the original presentation and the time that Judge Munyon's committee or work group came up with their November response or retort. And that restructuring we would like to take a little credit for because we thought that that was the better way to go, to divide it into non-evidentiary proceedings and evidentiary proceedings. We had a debate. One of the other issues that we considered was whether or not there should be virtual participation in voir dire. And the majority of the committee thought that of the 3 phases in which the criminal court, for example, would operate, the qualification of the jurors, the voir dire, and then the trial itself. And some of our members had a concern about whether or not it made sense to exclude voir dire if we were going to include the trial presentation. But there was such a hue and cry and a very vocal group among our members that said that voir dire should not be included, that the lawyers should have an opportunity to question the prospective jurors live and in person. The work group adopted or accepted our recommendation in that regard, but it again was a close call that we had as to whether there was a justification for the administrative excusal not being limited to in-person and the trial presentation not being limited to in-person, but somehow the voir dire, the middle piece of it, had to be limited to in-person.
Counsel, I'm going to let you keep going, but you are about 2 minutes over.
I apologize. I wanted to make sure that
But take a little more time. I just wanted you to be aware there is a clock there. So.
Thank you. Thank you. We agreed with virtually all of the other comments and questions that the work group had, and I think I'm finished. I think that unless the court has some questions, we took great pains to address this matter, and it appears that the work group actually started with some of our work product, and we're proud of that, and we thank the court and thank the work group.
Thank you. Now we go to those who are participating virtually. Mr. Stearns.
Thank you. Good morning, Chief Justice Kennedy, and may it please the court. My name is Jason Stearns, and I'm here on behalf of the Civil Procedure Rules Committee as the chair. I want to echo the comments of Mr. Solomon. Judge Munyon and her group did a remarkable job with the task that they had before them. We submitted some comments, and the majority of our comments were incorporated by the work group in its final report. There's one rule that remains, and I'm here to discuss just that one rule. That's 1.430D. This is the rule requiring or permitting participation by jurors in the voir dire process and the trial process. And the issue that the Civil Procedure Rules Committee has, the specific issue, is the timing component. The current work group proposal, and this is at page 39 of the Appendix A, requires that the written stipulation of the parties and motion be filed within 60 days of a jury trial demand.
Counsel, excuse me for a second. We need to try to get the volume up on this if we can.
I can speak up, Chief Justice, if you like.
Well,
Is this better?
I don't know that that's going to do it. I think the problem is here. It's not with you, and it may be.
Is this any better, Chief Justice?
No. But it's not. Again, it's not your problem. We're going to try. To address it. Bear with us just a couple of seconds, and it may be that this is the first time we've done a hybrid proceeding, so we are.
Let me know when I should proceed, Chief Justice Kennedy. I'm not sure.
Not right now. I'll let you know.
Thank you.
Well, if the volume is turned up all the way, then the volume is turned up all the way. So I think we'll just have to proceed and. Okay, let's go. Go ahead, counsel.
Thank you, Chief Justice. As I was saying, the issue that Civil Rules has with the current proposal is the time requirement. 60 days after a jury trial demand is within the first 3 months of the litigation. And our proposal is to leave the timing to the discretion of the courts, to remove the very last sentence of 1.430D. The penultimate sentence of that section requires both a stipulation and authorization by the court.
Could you repeat that? Could you repeat that again, please? Could you repeat that, what you just said?
Yes, Your Honor. The second to last sentence, 1.430D, requires the motion and authorization by the court. And so the concerns of the work group, logistics of remote proceedings, getting things set up and the timing can be handled on a case-by-case basis within the trial court's discretion. So we would recommend removing and striking the last sentence of 1.430D as proposed by the work group. And unless there are other questions by the court, that is all I have to say today. Thank you for your time.
Thank you, counsel. I'm sorry for the interruption. Ms. Rowe.
Good morning. Are you able to hear me okay?
We hear you very well.
Excellent. I made sure my microphone was turned up all the way. May it please the court, my name is Laura Rowe, and I'm here on behalf of the Appellate Court Rules Committee of the Florida Bar. The committee agrees with the work group, like many other participants here today, on most of their proposed amendments to the appellate rules, especially those governing mediation. I'm here today to address Rule 9.320, which governs oral argument. The committee and the work group both agree that the rule should be amended to incorporate the definitions of communications technology as it's included in Ultimate Rule 2.530 as adopted by the court, and to provide that when such technology is used, the appellate courts should make argument available by live broadcast and by posting the recording to the court's website. The primary difference between the continuity work group's current proposed amendments and the committee's proposed amendments is the inclusion of specifics regarding motions practice before the court. In particular, the work group's proposal to include a subdivision E2, which sets forth a procedure for requesting the use of communications technology, subdivision E3, which states that a court has the authority to grant or deny a party's request made under E2, or that it may order the use of communications technology on its own motion. And then subdivision E5, which provides a list of options the court may employ to address a technological malfunction should one occur. Because appellate courts already possess the discretion over the details of conducting oral argument and have successfully disseminated and employed their own practice preferences and procedures over the last 2 years, the proposed language is both unnecessary in order to allow remote oral arguments to continue, and it may have the unintended consequence of creating a procedural bar or otherwise limiting appellate courts in responding to new or developing technical challenges as they arise. A majority of the committee believes that
Counsel, I'm not following the procedural bar point. What would be the procedural bar?
Sure.
Bar to what?
A majority of the committee shared a concern that too much detail regarding the motions practice before the court and the options available to address technological malfunctions, especially, might create a procedural bar to certain modification of remote appearances that may be necessary and agreeable to the parties, depending on the circumstance. I, for one, am aware of no other appellate rule that provides the level of detail regarding motions practice as that currently proposed by the work group. Rules governing appellate motions do not contain separate provisions stating that the court has the discretion to grant or deny them, for example, or that describe what action the court might take to address an issue or a technological malfunction after the court issues such a ruling. And for example, hopefully this will help, the current proposal from the work group provides that parties might make a request for a remote appearance in their request for oral argument made under subdivision A of the current rule. This is actually inconsistent with current practice. Most Florida courts, including this court, permit parties to seek remote appearance by motion after filing a request for oral argument with the court. And this flexibility, our committee believes, is consistent with the use of remote oral argument to accommodate the needs of both the court, the parties, and the parties' counsel. Furthermore, the continuity work group subsection on technological malfunctions as proposed limits the court to either recess of the proceedings, granting additional time for argument, or dispensing with argument altogether. However, depending on the nature of the malfunction, the parties may wish instead to proceed with oral argument in spite of the issue, or the court's IT staff may nevertheless be able to accommodate the parties through a reasonable modification of the proceedings, as we just saw here today during this argument. So without the addition of this overly specific language, courts retain the discretion to modify argument based on the malfunction or based on the individual circumstances of the parties. And at this early stage in remote appellate arguments, courts should retain the discretion and flexibility necessary to address any problem that may arise during argument. Does that answer your question, Justice?
Thank you.
Thank you. So a majority of the committee believes that no rule amendment is currently necessary to permit appellate courts to continue using communications technology. Appellate courts already possess the discretion to allow for remote appearances at oral argument and have been competently disposing of oral argument, as I stated earlier, over the last 2 years while dealing with the ongoing pandemic and while applying this court's administrative order, SC 21-17. Consistent with the observations of several other commenters, including the Florida Bar's Board of Governors, the committee believes that judges are in the best position to balance the interests of the parties and the interests of justice in setting remote appearances, both at trial and the appellate levels. We agree with the continuity work group that communications technology should become a permanent fixture of appellate practice. However, any amendment to Rule 9.320 regarding appellate oral argument should preserve the discretion of the judicial panel and the court to ensure that oral argument is set and conducted with these interests in mind. At this time, a majority of the committee believes that it is still premature to impose rule-based uniformity on the practices and preferences of Florida's appellate courts, especially given the wide variety of developing circumstances to which they must respond in setting and administering the details of oral argument and remote oral argument. Thank you, Your Honors. If no one has any questions, thank you very much.
Thank you. Mr. Musto.
Thank you, Mr. Chief Justice, and may it please the court, Anthony Musto, on behalf of the Florida Civil Legal Aid Association, which is a group made up of the executive directors of each of the major legal aid providers in this state. Initially, I'd like to thank the court for allowing me to appear virtually. That was very important to me, and it is much appreciated. As far as the proposal that is before the court, it is a good one. We support it in principle. It will help our lawyers just as it will help other lawyers throughout the state and judges throughout the state. We do have some concerns, however, about the impact of the proposal on pro se litigants. And we suggest in our pleading several tweaks to the proposal that we believe will address these concerns. Your Honors, those of us who are on one side of the digital divide, the side where internet is inextricably woven into the fabrics of our lives, can very easily lose sight of the fact that there are millions of people from which our pro se litigants are mostly drawn on the other side of the divide. People who face significant hurdles in their lives because of their lack of access to the internet. And the biggest hurdle that is presented by the proposal that is before you is the requirement that these individuals file a form in order to opt out of e-service. This proposal creates a catch-22 for these litigants, because the only ones who are going to want to opt out are the ones who don't have internet access. But how do you get the form? You go to the court's website. If they don't have internet access, they can't go there to get the form. Yes, they can go to the courthouse, but that imposes a burden of time, expense, and trouble for these individuals. The goal of the form, which is to obtain the information necessary to know whether e-service will work, can be met in a much simpler manner. It is the manner that we suggest in our reply. We suggest that the same information can be obtained without imposing this burden on the pro se litigants by simply amending Rule 2.515B which deals with the information that litigants, self-represented litigants are required to put in their pleadings. They have to put their name, their address, and their phone number. That's fine. If we add to that a requirement that if they have an email address and internet access, they must include that email address, then the information that is taken up as required by the form is going to be provided to everybody. If there's an address there, they can be served by e-service the same as a lawyer. If there's not one there, then everybody knows that it has to be done through more traditional means. We do not suggest reject the form totally. It will be helpful in situations where circumstances change. They may have email access at the beginning and then lose it due to financial setbacks, and they may need to file something. But we do suggest that the form, whatever its breadth, whether it is the narrow one I suggest or the broader one suggested by the committee, whatever it is, the rules should be changed to say that it is the form or an equivalent pleading containing the information, which would get rid of the catch-22 and the trip to the court. In my remaining seconds, I'm just going to touch on two of the other suggestions we make relating to Rule 2.530, objection to a hearing being held online. It says, as written, that an objection must be made within 10 days. It doesn't say whether it needs to be filed or served within 10 days. We suggest that it should say served, with today's mail service being so spotty, and the fact that the order will inherently be will be sent by mail, and the objection will be sent by mail. Even the 10 days, even with the 5 days for mailing, there's going to be a lot of times where it will be very difficult to comply. Final point I will make today is that in ruling on these objections, the term good cause is shown. While we cannot have an exact definition of good cause, we do suggest that lack of access to the internet should be considered inherently good cause, and that should be put into the rules. With these changes and the others that we mentioned in our pleadings, we feel that this will be a much fairer process for both pro se litigants and a better process for the judicial system. Thank you so much, Your Honors.
Thank you, Mr. Musto.
May it please the court, my name is Mia Tell, former chair of the Alternative Dispute Resolution section of the Florida Bar. Chief Justice, are you able to hear me?
I am.
Thank you. And thank you for allowing me to appear virtually. Our section wholeheartedly supports the continued use of communication technology in court-connected mediations and arbitrations. However, I am going to discuss 3 proposed rule changes. 1, appearance rules for mediation and court-connected arbitration, which set personal appearance as a default and which need further clarification. 2, adding language to the appearance rules to allow parties to change the manner of attendance at the actual mediation or arbitration hearing. 3, revising the notice language in Rule 1.700A2. As to the manner of attendance, our survey results do not support a default or preference for in-person appearance. Absent agreement by the participants, the court should hold a hearing and determine what is the manner by which parties and the mediator will best be able to participate in the mediation process. We advocate for fairness and equal access to justice being the primary considerations given the facts in each individual case. Mediation appearance rules 1.700, 1.720, 1.750E, and 9.700, and the proposed family law rule 12.740D as proposed are not consistent and are unclear. For example, we request Rule 1.70 be clarified so that it is clear that it relates solely to mandatory non-binding arbitration and not voluntary binding arbitration, which cannot be ordered by the court. The rule should also make it absolutely clear that the written stipulations to mediation must be filed in the court file. This is important because parties and the mediator need to know if by signing a written agreement or stipulation to mediation that's not filed, whether they will fall within the scope of the 1.700 rules, which traditionally do not apply to them. So that word written stipulation should be in throughout Rule 1.700 that's filed with the court. That should be clear. Rule 1.700 should include a provision that at the time of the conference or hearing, quote, subject to agreement of the parties during the process, the parties and the neutral may agree to a change in communication technology as the need may arise to assure equal access to the process. This language in our comment will avoid delay in having to go back and obtain additional court orders or file additional written stipulations. It is unclear whether the notice which mediators have to send in Rule 1.700A2 must be filed with the court. We respectfully request that this be clarified and proposed 1.700A2 be changed. So we are not required to contain instructions for access to communication technology in court orders, filed written stipulations, or filed notices to protect privacy and mediation confidentiality. We do not believe that information regarding links, passcodes, telephone numbers, or other information regarding electronic communication should be filed in the court file. In conclusion, mediation appearance rules should be consistent for all types of mediation with an emphasis on party self-determination, without a default or preference for in-person appearance. We believe it is important to clarify what types of mediations and arbitrations are governed by the 1.70 rules, and that there be language which permits flexibility in changing the communication process as the need arises if agreed to by the participants. We urge the court to protect the privacy and security of court-connected mediations and non-binding arbitrations using electronic communication by amending the 1.700 notice rule to delete having to put forth the information regarding access to the communication technology. Thank you so much for your time.
Thank you.
I don't know if you have any questions of me.
Thank you. Mr. Apt.
Thank you, Chief Justice. May it please the court. I'm Alan Apt. I am the chair of the Criminal Procedure Rules Committee. I'm here in support of the work groups 3.116, 3.130, 3.160, 3.180, 3.191, 3.220, and 3.851 suggested revisions to those rules. Our committee, if the court does not know, the committee is broken down into basically one-third, 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 prosecutors, defense attorneys, and judges. And our committee generally has spirited debates on all of the proposed rules. Specifically, the committee addressed an addition to 3.116, which would be a requirement for non-evidentiary hearings to have remote technology to be used. The work group declined to adopt or to suggest that that be included in their amended rules, and suggested that it be done in a reform of a referral to my committee. And when my committee receives such referral, we would take it up if that's what the justices decide in their opinion. And I've yielded most of my time to the criminal law section, and I'll be available for any questions for the court.
Thank you, Mr. Apt. All right, now we come back away from the screen. Mr. Blank.
Good morning, Mr. Chief Justice, and may it please the court. Jason Blank. I am chair of the Florida Bar's Criminal Law Section. I'm treasurer of the Florida Association of Criminal Defense Lawyers and a member of the Criminal Procedure Rules Committee. And today I argue on behalf of all three. During the course of this pandemic and through the various waves and variants that we have seen, this court, by way of the Chief Justice, has administered multiple administrative orders to the trial courts of this state, dictating to them or advising them that they were to favor the use of remote technology in the criminal courts for non-evidentiary proceedings. Despite those orders and the further guidance that was given by the
Could you
Chief
slow
Justice-
down a little bit for me, Mr.
Yes,
Blank?
I'd be happy to. With only 4 minutes, I'm trying to
I
get
know,
it
I
all.
know.
But I will, Justice.
I will be generous. with
Thank
the
you.
time.
Despite the administrative orders by the Chief Justice, what we have seen throughout the state of Florida is that there are judges who are dispensing with the use of this remote technology for these types of non-evidentiary, non-essential proceedings. We are seeing that the use of Zoom or GoToMeetings or Google Hangouts, as the various circuits may use, are no longer being used, and the courts are ordering the lawyers and the litigants to be present before them for all matters, ministerial or non. That is why this court should adopt the proposed amendment set forth by the Criminal Procedure Rules Committee and the Criminal Law Section, which differs from the work group's proposal in that it mandates that when a request is made by one of the lawyers before a court for non-evidentiary hearings, that the court should and really must grant that request unless good cause is shown.
Why are we in a better world if we've taken away that discretion from judges?
The key here is that these types of remote proceedings and allowing the litigants to litigate their case in a fashion that they see fit by appearing remotely, much as Judge Munyon noted, if the lawyers wish to be represented remotely, why should they not? It is a more efficient, more effective, and more just system to allow.
So then why wouldn't you be able to persuade a judge to exercise his or her discretion that way?
And the idea behind the proposal by the Criminal Procedure Rules Committee is that the request or the motion, should it be such, to Justice Grosshand's earlier question, would be the initial persuasion. However, it would be incumbent on the court to find good cause not to. What we are seeing is that there are some judges who just don't like change. Some judges just don't like change. They don't necessarily want to use this remote technology. Maybe they're not comfortable with it. Maybe they just like to have the social aspect of having the lawyers before them, and that's certainly understandable. But nonetheless, we are in a...
Counsel,
Yes.
in fairness, at least I've been hearing a lot of behavioral problems of lawyers appearing on Zoom, dress problems, addressing the court improperly. There seems to be this attitude that all formality of the court proceedings are just out the window. So how do you answer that?
Yeah, I would argue to that, Justice Labarga, that while there may be certain instances where decorum or discretion of the lawyer may not be where it should be, and that may be an issue, that is not seen in the majority of remote appearances before the trial.
That also
courts.
happens in court, doesn't it?
And it does also happen in court, yes, Mr. Chief Justice. And I would also argue, Justice Labarga, that at any point in time, a judge can say, I'm ordering you before me at 9 a.m. tomorrow, be here with your client. Just like at any point in time, a judge can say, I find it good cause that you appear before me because I've seen you wearing shorts on Zoom, and I don't believe that to be appropriate decorum. The good cause provision in the proposal by the Criminal Procedure Rules Committee and as suggested by the Criminal Law Section allows for the court to still have discretion to order the lawyers and or the litigants before it at any given time. The main concerns, I see my time running out, so I'll conclude.
I'll give you a little more time.
Thank you so much, Mr. Chief Justice. The main concerns of the work group, and candidly of the minority position of the Criminal Procedure Rules Committee to some extent in their opposition to the proposal. In the Criminal Procedure Rules Committee, the minority said, well, we believe, and this really came from the judges, saying we believe that the appearance of the lawyers before us on the final pretrial conference before trial setting is important to hash out any remaining motions, any remaining issues, and possibly even resolve the case. We certainly, and I say we because I was a member of the majority on the Criminal Procedure Rules Committee that voted, we certainly understand that, and that is why we have the good cause provision, or the good cause safety valve, if you will, in the proposal. Were a trial court to feel that it be necessary that that final pretrial conference be held in person for those reasons, our position is that would constitute good cause. The work group's other objections to the proposal, really to take the language set forth by Justice Lawson earlier, are not legitimate concerns. The reason why is that the work group, and let me be very clear here, I appreciate the work of the work group. It's a very large undertaking that Judge Munyon had in her group, and they did a great job. But in responding to the amendments suggested by the Criminal Procedure Rules Committee, the objection was based on the fact that sometimes these non-evidentiary hearings somehow magically convert into an evidentiary hearing. Candidly, that's a fallacy. I can think of no time when a matter set and noticed as a status hearing magically turned into an evidentiary hearing and a court allowed it to go forward. More likely, and really what mostly happens in the courts around the state. The judge says, counsel, this is not what this is noticed for. Call my JA and get a hearing on special set calendar, or or show up tomorrow at 9 a.m. with the litigants or with your clients and the witnesses, and we'll address it then. So to the extent that that is the objection of the work group to the adoption of the Criminal Procedure Rules Committee proposal, I would argue it should not be given weight. Lastly, the work group suggests that this should be, and I apologize if I'm going fast, Justice Lawson, I'm trying to finish up here. Lastly, the work group suggests that this should be sent back to the Criminal Procedure Rules Committee to be considered. And that's based on the secondary carve-out that was set forth by the Rules of General Practice and Judicial Administration proposal to Rule 2.530. However, that's already been done, and to send it back to the Criminal Procedure Rules Committee would be redundant. This has been discussed, vetted, and proposed to both the work group and now the court as an amendment to Rule 3.116, or the proposed Rule 3.116, as a new subsection, and we would urge the court to adopt that subsection for the betterment of the courts in the state. Thank you very much.
Thank you, Mr. Blank. Ms. Morrison.
John Eddie Morrison on behalf of the Florida Public Defender Association. Thank you so much for allowing us to appear here today. Given the work group's amended proposals, we will address only issues 2 and 3 in our written comments. Both of them turn around the same principle, which is that although video hearings are often useful and helpful, a good option, they should never be the only option when liberty is at stake. That is the fundamental heart of this court's decision in Doe. This is how we have done jurisprudence since there has been jurisprudence. And that has not changed with technology, particularly for our mentally ill citizens. I, by sheer coincidence, yesterday was reading through a transcript of a schizophrenic young man who was explaining to a judge in all sincerity that the witnesses in the little boxes on Zoom could have been anybody. He speculated that they were his mother. This is not a problem technology is ever going to solve. This is a situation with our mentally ill clients. They should be the very last people whose liberty should be subjected to curtailment based on a video hearing when they walk into a small room with a desk and a computer and the Hollywood squares of a Zoom meeting. Let's just be honest. Many of these clients have schizophrenia, paranoia, all sorts of mental symptoms of their diseases. Their grasp on reality is often slippery, and it is not helped by, as Justice Labarga suggested, some of these Zoom hearings, they're simply more informal by the sheer nature of the technology, even as we saw this morning in the hybrid part of this proceeding. Technology is just clunky. It doesn't feel the same. It doesn't feel real. And we all know the difference. We all know the difference from, you remember the first time we got to see our relatives in person again after only seeing them in video. There's a difference. It matters, and it's important. We are grateful for the work group's understanding of this principle in Rule 3.116, when the work group amended it to provide that in criminal cases, defendants should always have the right to appear in person before a live judge unless they waive that. And many times it'll be convenient and useful for everybody to waive, but when it's not, when a defendant wants to appear for whatever type of hearing, and often the hearing's important in criminal cases, as this court knows, very few criminal cases go to trial. Percentage-wise, it's a minor fraction. The important hearings are the motions to dismiss for stand your ground, the motions to suppress, the bond hearings. And the defendants always have the right under the work group's amended proposal. We appreciate that. We believe that is the correct principle, and we believe that that should be applied both in the criminal cases and in the Baker Act Marchment proceedings. Those are my comments. I'll take any questions from the court, in which case I will cede my 24 seconds to the Florida Disability Rights.
Good morning. Mr. Chief Justice, and may it please the court, I'm Caitlin Clibben with Disability Rights Florida.
Could you speak up just a little bit?
Yes.
Thank you.
Do my best. I'm Caitlin Clibben with Disability Rights Florida. Disability Rights Florida is the designated voice for those with mental illness in Florida and has a long-standing interest in making sure that the proceedings relating to the Baker Act are fair and protect the rights of those individuals with mental illness. Disability Rights Florida urges this court not to adopt the changes to Rule 2.530 as they relate to Baker Act proceedings. We urge you not to overturn Doe and not allow remote Baker Act proceedings at the court's discretion and over objection of the person subject to that hearing. The justifications offered to have remote hearings in Baker Act proceedings ignore the incredible vulnerability of those who are subject to the Baker Act, as my colleague just discussed, those with mental illness, and it ignores the increased scrutiny that is due to them anytime their rights are at stake. In Doe, in 2017, this court gave that careful scrutiny to this question. In Doe, the court considered reports from this court's own subcommittees and work groups, from the Department of Children and Families, from Baker Act experts, from legal service providers who work with those with mental illness, and a failed pilot program for remote delinquency hearings, children being a similarly vulnerable group. And in Doe, this court balanced all of that evidence against cost and efficiency of technology, and decided that.
Given the state of technology today, do you think it would be possible to put together a Baker Act hearing room on both ends that would provide a better environment for the population that you serve? Because courtrooms can be really intimidating. Some of the rooms that I've seen where Baker Act hearings are happening with all the chaos going on are really not good now. It seems like, given the savings of having judges drive across the county and all the disruption, that we might be able to fund something that on a case-by-case, courtroom-by-courtroom basis, we could come up with something that would even be better than what we have. Do you think that's possible?
I think that's right. And what you said on a case-by-case basis, I think that's the key there. I think that for those, like my colleague just described, who are having severe paranoia delusions, even a very nicely set up courtroom may not be sufficient to allow them to meaningfully engage, and may cause them to honestly just opt out and refuse to appear at all and not have any participation in their hearing. And like you said, I think it's a case-by-case consideration that needs to be made. But courts should not be allowed to, over the objection of that person or their attorney, force them into a remote proceeding when they're saying my mental health will not allow this to go well.
Thank you very much.
So in Doe, this court really carefully considered all the potential impacts to people subject to the Baker Act proceeding. And in this petition here today, that careful, methodical consideration is not reflected. I don't see surveys of mental health experts, surveys of folks who are subject to the Baker Act proceeding or their families to find out if they've experienced negative impacts. We're not seeing, and during the pandemic, because it's still ongoing, there has not been a reasonable basis for attorneys to object to remote proceedings and describe these negative
Counsel,
impacts.
Is there have we ever overturned a constitutional ruling in a rules case? I'm not talking about changing a rule because we decided that the policy and the rule needed to be changed. But have we ever, when there's a due process holding in Doe, have we ever changed a constitutional holding like that through a procedural rule?
Mr. Chief Justice, I am not aware of this court having done that.
Has that been cited anywhere in this proceeding?
No, not that I have seen in any of the materials provided. No evidence for that having happened before. And I know I'm out of time over here, so I will just wrap it up and say that the careful, methodical consideration given in Doe is what's due to people with mental illness, these incredibly vulnerable folks who often are unable to advocate for themselves effectively. And we simply ask that this court recognize that Baker Act proceedings are unique and they're specifically designed by the legislature to protect the rights of the individuals subject to them. They're not just any hearing, and we ask you not to lump them in and not to treat them as just any hearing. Thank you.
Thank you. Judge Munyon.
Thank you, Chief Justice. Unless members of the court have any questions, we would rely on our petition and response.
Could you address the legal aid organization's concern about the opt-out for those who have no internet service?
And Justice Polston, are you talking about opting out of a virtual proceeding?
Yeah, as I understood, his concern was that the default is electronic unless you opt out in some way, and he expressed that that would be difficult for some people who have no internet, as I understood his argument.
Yes, the opt-out of the email service and using the form. Forms, pro se litigants find the forms that have been instituted by this court pursuant to rules petitions. They're readily available at the courthouse, on the internet, in law libraries, and they find them because we see that they find them, they file them.
It seems like I was trying to picture of the group of people he might be talking about, and I mean, in most places in cities and stuff, I mean, you find the nearest McDonald's, right? And you can go in, or a fast food place. At least in my neck of the woods where I come from, there's no McDonald's. So in very rural areas in the state, which exist, I see those as perhaps the most problematic of having access to internet. So that's the population that I think would perhaps struggle the most in being able to find some type of access. Is there some means for them to easily deal with the situation he was describing?
I believe that they could find the forms at the courthouse, the law library, the library, other places that they might either have internet access or access to actually written materials. But the same issue arises even if you just change the rule. Without some access to the rule book, they're not going to know that the rule changed and that they have to provide their email address as part of the certificate above their or below their signature. So I don't believe that it is a real obstacle to people providing the form to the court.
But what's wrong with what Mr. Musto suggested? Why would that not work? They give the email. Are you afraid that people who actually have email addresses are just going to decide they don't want to play in the email world?
Absolutely. We see that happen now. We see that happen. I think I'm very reticent to give my email address out to many people. They ask for it, say, "Why do you need it?" I'm not going to put my email address in this particular form because I don't want you to send me junk. And I do have concerns that there will be gamesmanship, and that it is one thing not to put your email address in your certificate. It's quite another to say under penalty of perjury, I don't have email or I don't have access to internet.
Help me understand the gamesmanship.
Yes.
Okay, so I purposefully declined to provide my email address because I would like this proceeding to happen in person. Right?
No, I don't provide my email address because I don't want to receive court documents or documents from the attorney on the other side or the litigant on the other side via e-service. I want to sort of slow down the proceedings and have that 5-day mail rule applicable to every document in the case.
Kind of an obstructionist tactic.
And it's something that reared its ugly head in the foreclosure crisis. We did see those sorts of games being played at times. Thank you.
May it please the court. Your Honors, I just want to touch briefly on the comments that were raised by Mia Tell regarding the mediation rules. The first comment she made was that she wanted the parties to be able to stipulate midway through the process to change the format of remote technology if that became necessary, as opposed to having to adjourn the proceedings, go back to the court, and get a new order or have an order incorporate a new stipulation. I think the response to that is that, first off, the rule is written as it is to allow the trial court to retain the ultimate authority over how the proceeding will go if it wants to. But absent that sort of control by the trial court, there is nothing that would preclude in this rule the parties from making whatever stipulation they want up front, which can include a stipulation that should it be necessary to change the format of communication technology. If somebody's going to be in a remote location and they may not have reliable internet service, we can switch just to audio technology for that person if the parties agree to that. The next thing she mentioned was that appearance requirements should not have a default in-person requirement. Well, right now, physical appearance is the default requirement unless the parties or the court, unless the parties stipulate or the court orders to the contrary. The work group did not change that. All the work group has done is to memorialize that remote communication technology can be used either in whole or in combination. And then finally, the notice concern, that actually is a legitimate concern if the notice has to be filed with the court, and if the notice that's filed with the court gives away say the password for a Zoom link. There's usually a user ID or a meeting ID and a password. If the mediator is designated to give notice and can give that information in an engagement letter that is not filed with the court, or can provide it in a separate notice in addition to the notice that must be filed with the court, then I think that alleviates the concern. But if notice is construed as an engagement letter, which would put the parties on written notice, that's not filed, and I think those security concerns go away. Thank you very much.
All right, thank you. We thank you all for your participation in today's argument. Again, I want to thank the work group and all the commenters, including those who not participate in argument, for your participation in this process. We appreciate it very much. The court will now stand in recess for about 10 minutes.
All right.
That's fine. Supreme Court of Florida is now in session. Please be seated.
The court will now take up the case of Dial versus Calusa Palms Master Association. Counsel.
Mr. Chief Justice, and may it please the court, Alex Brockmeyer on behalf of Elaine Dial. I would like to reserve 5 minutes for rebuttal. We're asking that this court answer the certified question in the affirmative because in Jorg versus State Farm, this court made clear that Medicare is a collateral source and that Stanley's exception to the evidentiary collateral source rule does not apply to Medicare. And in doing so, this court said that there was no distinction between past or future medical expenses paid by Medicare. And with Stanley's exception being said to no longer apply to Medicare payments, that places us, as Judge Rothstein-Yoakum noted in her concurring opinion below, back squarely within the confines of the evidentiary collateral source rule. And that evidentiary collateral source rule, as Calusa Palms agrees with me, that is a rule that per se bars any evidence of collateral source payments in a liability trial from being admitted into evidence. And then post-trial, how this has worked is that the trial court, outside the jury's presence, reduces any award of medical expenses pursuant to section 768.76. And that was actually the exact approach.
Let me ask you this series of questions maybe. What is confusing to me about the way this case is presented is we're really talking about evidence, whether something should have come into evidence, correct?
Correct, Your Honor.
Okay. And we're dealing with past medical expenses as if the evidentiary analysis of relevance is the same, whether it's compensatory or non-economic damages, correct? I mean, we're just lumping it all together.
I mean, I think in Gormley, this court said that we're not going to have any sort of relevancy sort of analysis with collateral source rules. It's a per se rule of...
But it's not a collateral source by statute, correct?
Well, but Gormley said that we're not going to let 768.76 dictate the admissible...
We're only talking about the evidentiary collateral source rule.
Right. The
Okay.
768 is completely separate and distinct from our common law evidentiary rule.
So what is the relevance of that evidence to compensatory damage claims?
Well, so it's relevant to the reasonable medical expenses that a...
But that's not relevant to compensatory damages, correct? Because with compensatory damages, what you get, the jury has to reimburse your client, assuming liability, for what they paid. That's compensatory damages.
Well, so I would direct the court to the second district's decision.
And we're just talking about, so you're in court, you say, I want to put this evidence in, the amount of the reasonable, or what was actually would have been billed if it weren't for Medicaid, what was originally billed, in order to prove compensatory damages, objection, relevance. What's your response to the trial court?
Well, one, there was no relevance objection made below.
I know.
So we would submit that that argument hasn't been presented, but I would say, Your Honor, Gormley says that relevancy is not an inquiry. We're not engaging in any sort of 403 relevancy versus probative analysis.
Okay, but stick with me. We're talking about an evidentiary issue. All relevant evidence is admissible. But to be admissible, it has to be relevant. That's sort of foundational. And I cannot see the relevance, given the statute, to the issue of compensatory damages.
Well, so we look at cases like the second district's decision in Goebel.
Okay, just stick with me.
Well,
Can you tell me what the relevance is?
I'm trying to, Your Honor. And I think Goebel, Nationwide versus Harrell, and Durst versus Henn are all...
How does it tend to prove or disprove a fact?
It goes to prove the reasonable value of the medical expenses. And
how is that relevant to compensatory damages?
Because at common law, the jury instruction says you're entitled to recover the reasonable value of the medical expenses, and at common law, a plaintiff is entitled to recover the full value of the reasonable and necessary medical expenses caused by the tortfeasor's tortious conduct without reductions for collateral source payments.
But you concede that that's not true with respect to Medicare, right?
I agree they get to a post-trial reduction, yes, because of 768.76
Right.
for the write-off amount. But then we go and look at how our courts have addressed this in the context of...
But to be legally relevant, I mean, given the statute and what is just true about how the case is proven, I'm having a hard time, as you can tell because of my questions, understanding the relevance to compensatory damages.
Well, and we keep that evidence out, Your Honor, because of what this court has consistently acknowledged is the inherently prejudicial effect that this collateral source evidence has on a jury's determination of both liability as well as damages. So it's not just it's an exclusionary rule is why we keep it out, but it is relevant to other issues in a case. Take, for example...
Non-economic damages.
Non-economic damages, which my
opponent... And both sides seem to acknowledge that there would be an argument that the information is relevant to non-economic damages.
Well, which is why it would be admissible.
But that argument was never made below. In other words, there was never a... Was that argument made below? It's relevant to non-economic damages?
Yeah, I argue that to Judge McHugh in the motion for reconsideration, both pre-trial and during trial, and we raised it at the second district as well, Your Honor. And it's also relevant. Now, this part is not relevant to our case, but keeping in mind that this court is making a rule for cases as a whole, future medical expenses, where there is the plaintiff is entitled to recover the full value at private market rates, because where Medicare makes a tort payment, there is no ability for Medicare to come in and then pay.
And if you were going to offer evidence at trial on the issue of non-economic damages, it seems to me that what you would need to do is have an expert as to the reasonable value of that in the community, and maybe it would be also admissible, the particular billed amount in this case. But that seems like if you're offering evidence that's relevant to the issue of non-economic damages, you would go about it a very different way. You just couldn't stick in, this is how much perhaps, I'm not sure, but the way the case is argued, it's not argued that this is admissible to non-economic damages. It's sort of just argued that the law either allows it because it's passed or doesn't allow it because it's passed.
Well, again, we did argue at the trial court level and the second district that this was relevant because, in part...
Can you tell us again, how is it relevant to non-economic damages?
It's a qualitative assessment of the severity of the injury caused...
So basically, it's the magnitude of the injury.
Correct, Your Honor. And
right, so let's say that I'm walking down the street and I have this kind of karma. Okay, a street sign falls on my head, and I'm rushed to the emergency room. Surgery, and there's no health insurance. I'm just a guy with no job, no Medicare. I'm too young for that. There's no workers' comp. There's nothing. So I suspect that 3 months later, when I'm recovering, I'm going to be getting some bills from the hospital. Let's say they add up to $120,000, and I don't pay them. I suspect that I'm going to be paid a visit by bill collectors from the medical providers. Would that $120,000 be admissible during my case?
I think it would, because
Nobody's recovering from, I mean, the jury will have to pay me $120,000 if they rule in my favor, and there's no lien from Medicare or workers' comp or anyone else. So I will be receiving $120,000 to reimburse the providers.
Correct, Your Honor.
Right. And in that particular case, there would be no collateral source rule or anything involved.
Correct,
No.
it would just be,
So the jury will get to hear that I had basically extensive medical treatment. I didn't just go to the emergency room, got a couple of stitches, and went home. I actually had surgery with an anesthesiologist, with a surgeon, the whole works, and then recovery.
right.
Right. So it would, the relevance that the reason you, as a plaintiff's lawyer, would want to introduce that is to show the jury that these were severe injuries, and that's how much it costs to treat you.
Absolutely, and
Now-
that's what we argued to the trial court on the second.
Now, let's say
district.
that I have Medicare.
Mhm.
I'm walking down the street, the sign falls on me, I'm taking an emergency room. And the bill's $120,000. Providers are told by Medicare, using their standards, their guidelines, that we're going to pay you 25 cents on the dollar, and you're going to take that. So under those circumstances, the way the case is in this case, the jury will only hear that Medicare paid $25,000. Not Medicare, but that $25,000 would be the ones that the amount the jury would hear that was incurred. So because I have Medicare, that magnitude argument won't be available.
Absolutely, you're seen as less injured because a collateral source is there to compensate for the medical expenses. And what the cases all say is that we shouldn't be letting a collateral source affect how the jury is assessing the damages.
But one aspect of the argument of relevancy is not just the economic matter, is also the non-economic, in being able to argue to the jury that the injuries were extensive. And that's one way to show it to the jury.
Absolutely, and Calusa Palms agrees with that in their brief. I mean, I think when we read their brief, they acknowledge that this is relevant towards the non-economic damages, and we've argued that consistently throughout this case. And that's in fact what cases like Durst versus Henn acknowledge, that it is relevant to show the non-economic damages.
I'm sorry to interrupt you. Could you address the source versus amount issue that one of the amici raised, kind of in the context of what the purpose of the collateral damages rule is getting at, in the sense that if you can introduce the amount of, the bills without getting into, how it would be paid for, by whom, or whatever, why doesn't that take care of whatever the prejudice that might, that led to the creation of the rule in the first place?
Certainly, Justice Muniz, and that's kind of what the trial court attempted to do here. But we can see from the jury's question, the first question they asked when they retired to deliberate was, did insurance pay the medical expenses? That approach indirectly does what the collateral source rule directly prohibits, and that's what cases like Wills out of the Illinois Supreme Court, Lettinger out of Wisconsin, the Weston versus A.K. Happy Time case from Alaska all acknowledge, which is that it's still going to put questions in the jury's mind as to why is this amount so low and why is it out there, and it's going to still affect their assessment on liability and damages.
And why, as far as, to Justice Labarga's questions, I mean, if the goal is to make sure that the jury understands, the severity of the injuries and the care that was necessary, I mean, why couldn't you just present evidence of all the medical procedures that the person went through, and who cares what the cost was? I mean, if, you know what I'm saying? If you're trying to, there's one part of the evidence is to get to compensation, and part of the evidence is to get to the, how extensive were the injuries and whatever, to the extent that there's that other thing that's kind of separate from the compensation issue. why isn't it enough that the jury just hears what the person went through?
Well, it's still relevant evidence, and it's showing the severity. I mean, the amount of the treatment certainly
The
makes
cost,
it.
why, I mean, if I have 4 surgeries and the jury hears that,
Well-
why does it matter if they hear some, phantom amount that is technically billed versus what's paid? I mean, I don't understand.
Well, because
I don't
it's.
understand that.
Oh, sorry, Justice. Again, I go back to what cases like Wills, the Happy Time case, our cases in Florida consistently have said, it's going to affect how the jury's looking at this, and it's going to cause them to think that there's already been either sufficient compensation, the severity of the injury isn't different, or is different based on essentially what the court in Robinson versus Bates talks about is people are going to be seen as being injured differently just because of the nature of the source that's paying their medical bills. And what the collateral source rule says is we shouldn't let that be driving the horse here in terms of the admissibility of evidence or inadmissibility of evidence.
Well, I understand what you're saying, but it seems like to me that to kind of assume that there's some proportion between some amount that might be exorbitant that is billed and the pain and suffering. That seems to be a logical, one does not necessarily follow from the other.
Well,
I think people could very well understand that you might be billed an enormous amount of money for something that wasn't very, very painful at all.
Well, and
it seems like you're trying to just, that sort of information may actually exaggerate in the minds of the jury the injury that was suffered. Why isn't that a legitimate perspective on it?
Well, I think what the cases say is that if a defendant wants to take issue with the amount of the medical expense, we looked at what cases like Goebel say, which is you can certainly cross-examine the treating physician and say, you charged $100 for this shoulder surgery. It really should have cost $50. Or you can call in your own expert and say, Dr. So-and-so, you do shoulder surgeries all throughout the state of Florida, and you do a lot here in our case, Lee County. And what do you routinely charge for that? You can get into all that evidence, and that is, as this court has said, less prejudicial than...
It seems like the focus there is on the economic damages. And we know what those were because it's been paid.
Well, but it's not...
So this is kind of morphing over into the non-economic damages. And so I'm just trying to understand why that necessarily is a right way for the jury to be evaluating the non-economic damages.
Well, it's all relevant evidence for the jury to consider. I mean, there is no exact measure for evaluating non-economic damages, but the way I look at it, Justice Kennedy, or Chief Justice Kennedy, apologies, I don't mean to give you depromote you.
I'm not sensitive about that.
Is to just say that it's all relevant evidence, but at the end of the day, what we're
let me just question that. In Chief Justice Kennedy's example, where you have an exorbitant bill for something that a lot of money spent for something that wasn't very painful at all, what would be the relevance of that figure, the legal relevance to non-economic damages?
I mean, I think we go back to what's already, my opponent's already conceded, is that it shows the severity or lack thereof of the injury. If a defendant wants to contest and say, I don't think this is a severe injury, the surgery should not have cost that much.
But why confuse it with the money? As Chief Justice Kennedy said, why not just look at what actually happened, the procedures, and which the jury does anyway?
Because what you're going to end up doing is affecting how the jury is compensating a plaintiff for their damages, which this court has consistently said, we're not going to let a plaintiff's recovery be reduced or adversely influenced by collateral source payments. That's essentially what that is doing. And I go back to what this court has said in Gormley, what this court said in Jorg and Sheffield, and our district courts have consistently said since this collateral source rule first emerged, I think in the mid-50s in this state.
Counsel, we have taken you into your rebuttal time. I'm going to give you a little extra time, but you need to...
Certainly.
I'm sorry, before you do that, can I just ask you one quick question? Just to focus on the narrow issue of what the certified question is. It seems, it's phrased in terms of does the holding of Jorg ... it seems like we're kind of talking more about should the holding of Jorg. I mean, if the question is, does the holding of Jorg, apply in this context, it seems like Jorg is clearly talking about future expenses, and it gets into all the speculativeness, and the programs may or may not happen, and yada yada. Is your whole argument that Jorg applies here just tied to the footnote and the comment about the Illinois case?
It's not, Your Honor. I think first, Medicare is a collateral source, right? So it's compensation independent of the tortfeasor, which is how this court defined it for evidentiary purposes in Gormley. Then the second part is, does Stanley remove Medicare from the evidentiary collateral source rule? And what this court in Jorg said was no, Stanley does not apply to Medicare because there's a right of reimbursement. That right of reimbursement is going to exist regardless of whether it's a future payment or a past payment. It's there statutorily. That means Stanley doesn't apply. I do think that goes to show the footnote, the immateriality of the distinction, which makes the broader rationale of Jorg applicable to both past and future expenses, though. And we can also see this, and I think on Pin Site 1255 of Jorg, it talks about how we harmonize the dual purposes of the collateral source rule, the evidentiary and the statutory component. That statement about how that harmonization is to work has to have been in the context of past medical expenses rather than future expenses, because under this court's decision in Rudnick, 76876 doesn't apply to future expenses. So that has to be talking about the past expense at issue here. But to the narrow question, we think the answer is yes. Thank you.
All right, counsel, I will give you a total of 3 minutes for rebuttal.
Thank you.
Even though you've got 37 seconds left.
May it please the court, Mr. Chief Justice, Justices. My name is Michael DeLugo from the law firm of Wicker Smith in Orlando, and I represent Calusa Palms. This case presents an interesting issue because we have diametrically opposed views of whether or not Medicare is a collateral source. The legislature says it isn't. 768.762B says benefits received under Medicare shall not be considered a collateral source. Ms. Dial relies on the Jorg decision of this course. Jorg says that Medicare is not a collateral source. In Jorg, the court stated it, referring to the Stanley exception to the collateral source rule, was never intended to apply to benefits from Medicare or Medicaid or to collateral sources. Well, if this court considered Medicare to be a collateral source, it would have said it does not apply to Medicare, Medicaid, or to other collateral sources. It doesn't say that. So both the legislature and this court have stated that Medicare is not a collateral source, and that's why Ms. Dial's argument fails. The whole issue here is, should the jury be able to consider damages for which the plaintiff will never, ever be held responsible? Medicare providers accept the premise that if they're going to provide services under Medicare, they're going to accept whatever Medicare is going to pay for those services. So they can bill whatever they want, but they know that if they're providing these services, that's the amount that Medicare is going to pay. And compensatory damages compensate. If the plaintiff is never going to be responsible for those excess charges, then how could Florida law even recognize that?
And so if your client is going to be, I'm sorry.
It's okay, you go ahead.
If your client is going to be reimbursed pursuant to statute, I mean, if, let's say the jury came back with $120,000 in this case, you were going to come back to the court afterwards under statute, and the judge is going to reduce that to the Medicare amount.
If
so
it's a
what's the downside for you here?
Justice Margo, that would happen if it were a collateral source. That's
Right.
how it works with insurance, private insurance, for example, that the tortfeasor should not be able to derive some sort of benefit from the plaintiff being responsible and having health insurance. With that said, the amounts that Medicare pays, it's all premised on the fact that there is a right of reimbursement under Medicare, on the Medicare Medicaid Secondary Payer Act from 1980. And so there is only a right of reimbursement up to the amount that the doctor, the Medicare provider, accepted in full and final payment for the services that were provided. That's the difference between Medicare payment and a private health insurance payment, is that CMS, the federal agency, the Center for Medicare and Medicaid Services, has the ability to come back and get that money back after the primary payer, Medicare being the secondary payer, The primary payer is the tortfeasor or the insurer for the tortfeasor. And so that's the distinction, and that's why in private insurance, it is handled post-trial with a set-off, a reduction of the jury's verdict. But in the case of Medicare, because it's not a collateral source, it is only the amount that the Medicare provider accepted in full payment for those damages that is the compensatory damages, and that's all the plaintiff is able to argue.
The key difference, isn't it, that in private, that has a contractual amount similar to Medicare here, like in the Goebel case, they treated the discounted amount as the collateral source payment. But here, in Medicare, there's a statutory provision that says you can't do that.
Correct.
So it's that distinction between the private and the Medicare that causes the argument, oh, put in the gross amount, but you don't have the collateral source set off because there's a statute that says you can't do it.
That's correct, and that makes all the difference. Justice Groshans?
That actually answered most of my question, but I will say, is it Calusa Palm's position that this court should narrowly answer this question that the second DCA had, or is it Calusa Palm's position that we should consider what effect this might have on private insurance or the whole collateral source rule?
I don't think it does have any impact on the collateral source rule, precisely because Medicare is not a collateral source. So I think that what Calusa Palms is looking for here is an affirmance and an explanation that the cooperative leasing holding is still viable and still should be applied by Florida trial courts, and that is that the jury only gets to hear, in the case of Medicare, the amount that was accepted as full and final payment for the medical services provided, and not the amount that was originally billed, even when that number is much, much higher than what Medicare would ever pay. These damages, the difference between what is billed and what is paid, are frequently referred to as phantom damages, and I think that that's an appropriate description of them because they're not damages at all. The plaintiff will never have the obligation to pay any amount over and above what a healthcare provider accepted from Medicare.
Well, it seems like that same argument really should apply in Goebel, in the majority opinion there. I mean, they're arguing for the same treatment for private and Medicare. That seems right to me, that I don't see any real reason why you should treat them differently, but it seems like at least Justice Bell in his concurrence had it right in the Goebel case, where you should be putting in what you've agreed to pay in the discounted amount into evidence.
Well, I mean, the difference is that Medicare is not a collateral source, and so and CMS has the ability to seek reimbursement for the amounts that were paid once there is a payment from a primary tortfeasor or a primary payer, in this case a tortfeasor or the tortfeasor's insurance carrier.
It seems a stretch to me to treat a discount as a collateral source payment.
It's not. There is a lot of argument contained within Ms. Stiles' briefs about the fact that the Jorg court receded from the Stanley opinion, and clearly I don't dispute that, but what I do dispute is the sort of implicit argument that merely because the Jorg court receded from Stanley, then every single case that ever cited to Stanley favorably is necessarily going to be wrongly decided, retroactively wrongly decided. That is not true. The cooperative leasing case is still the appropriate way to approach this. The ThyssenKrupp elevator decision out of the 4th District is the appropriate way to address this issue. There is simply no logical basis under Florida law to tell the jury about damages that aren't damages for which the plaintiff will never have an obligation to pay. And it doesn't make any sense to me that we would try to avoid confusing the jury by misleading the jury. Okay? That is not how trials should be conducted. It should not be up to the defense to cross-examine plaintiff's experts or hire their own experts to try to combat the providing of misinformation to plaintiffs. This is simply not an actual damage under Florida law, and so if there's nothing to compensate, it cannot be considered compensatory damages. And unless the court has any further questions, I will rely on our brief. Thank you.
Rebuttal?
May it please the court. The Weston case, I think, is a very good guidepost for this court. Alaska has a statute, just like 768.76. The plaintiffs there are allowed to recover the reasonable value of medical treatment, just like here in Florida. And in Weston, the court said that the write-off amount constitutes a collateral source because it is some sort of benefit that the claimant's receiving from a third-party source. And the court said that in the context of Medicare.
Well, it seems like it would make more sense if you put in the amount that you're actually liable for. What comes into evidence is the amount that you're actually liable for by way of expenses from a medical care provider, not some amount that's whatever it may be, but it has no real relevance to what's going to get paid.
Well, so again, it's been conceded in the briefing that it is relevant towards the non-economic issue.
Isn't the problem here on Medicare, unlike a private situation, where if you put in the gross amount, in this case the 120, but only 34 is ultimately going to get paid, that's not going to get reduced from the judgment because of the subrogation right Medicare has. But you put in the gross amount, there's $86,000 that a jury is going to hear and actually put in a jury verdict, most likely for economic damages, would they not? So isn't that the real problem?
And that would be reduced post-trial. I think that.
How?
Because, like cooperative leasing explains in footnote 1, there's a difference between the write-off amount and the amount of reimbursement. The reimbursement amount is accepted under subsection 2B. But what cooperative leasing says is that write-off amount is still a benefit paid for the claimant that should be reduced post-trial.
Well, in Goebel, as a private got set off, they treated the discount as part of the collateral source. And that's where that discount got set off. But here your argument is, I think properly, the statute says otherwise. The statute says there's no collateral source, right? Isn't that what it says?
To the extent there's a right of reimbursement. So the trial court cannot say, just for example, let's say there's a $100 bill. $20 is what the right of reimbursement's for. $80 is the write-off amount. Only the $20 is accepted from the definition of collateral source under subsection 2B of the statute. That $80, though, is still something paid for the benefit of the claimant under subsection 1, which, consistent with Goebel, can be set off from the award. But, of course, all this is talking about 768.76, which this court has already said does not affect the evidentiary rule, because at common law, the evidentiary and damages rule were separate and distinct. And our legislature has only seen fit to alter the damages collateral source rule. The evidentiary rule is alive and well. We shouldn't let the legislature's abrogation of a damages component affect our evidentiary rule, especially when this court has said we're not going to do that already in Gormley and Jorg.
Let me just go ahead and finish.
No.
I was just going to clarify. So when I was asking questions earlier, I may have said that your opponent conceded that it was relevant to non-economic damages, and I think more precisely you'd probably agree what they suggested in the argument is what you suggested, is it as a matter of fact that damages tend to be higher, non-economic damages tend to be higher in cases where the medical expenses are higher. But that doesn't necessarily mean that there's a legal relevance to non-economic damages, and I don't think that they ever conceded that. Is that correct?
I believe in their brief that was conceded that the collateral source or the gross amount is relevant towards the non-economic damages, Justice Lawson. And may I briefly conclude, Chief Justice?
And how could that be made, that decision as a matter of evidence be made on anything but a case-by-case basis? I mean, as a matter of law, it's always relevant? Is that what you're suggesting?
Well, I'm suggesting to the court that it's certainly probative to the severity of the injury, and the collateral source rule says that we shouldn't be allowing the jury's damages determination to be adversely affected by collateral source payments.
Thank you.
And because the evidentiary collateral source rule is alive and well, and this court reaffirmed that in Jorg, Medicare falls within the scope of that rule, we'd ask this court to answer the certified question, yes. Thank you.
Thank you both for your arguments. Court will now take up the case of Emerson versus Lambert.
Good afternoon, and may it please the court. Mr. Chief Justice, Justices of the Supreme Court, I'm John
It
Mills.
seems like it's afternoon, but it's not actually.
Oh, it does seem like it.
I'm with you, though.
Well, good morning. We have an extra hour. I'm pleased to represent Bruce Emerson, the petitioner in this case, and we ask that you answer the certified question in the affirmative and quash the decision below. I have already, I believe, reserved 5 minutes for rebuttal. The dangerous instrumentality doctrine, which is at the center of this case, comes from the common law in England. When this court in Southern Cotton Oil in 1920 applied that doctrine to the automobile, it cited the Dixon v. Bell case back from 1816 before the King's Bench, which said that persons having in their custody instruments of danger are taking on the risk when they put it to somebody else of that person's judgment, and they're going to be liable. And again, in 1920, this court applied that to the automobile. Today's case deals with the liability of what we call an intermediate bailee. This is a person who is a bailee as to the title owner because the title owner has given them possession and control of the vehicle to do as they wish. They're a bailor as to the tortfeasor because they then entrust it to the negligent driver, tortfeasor. As early as 1951, this court held that it does not matter whether the defendant holds title or holds a bailment interest under the dangerous instrumentality doctrine. It was not because it's not necessary to prove actual title, but only to establish who exerted such dominion over the truck as to be responsible for damages caused by it. That was the Wilson versus Burke decision. A few years later, in 1959, this court considered two companion cases, Fleming versus Alter and Frankel versus Frankel, where it held that all three entities are responsible. The title holders, there were actually two in that case, the intermediate bailee, who was Frankel, and I think in a couple places our brief mistakenly calls him Fleming, but it was Frankel was the intermediate bailee who took possession of the car from the title owner. And then he let his...
A bailee for hire.
That was a bailee for hire, and subsequently, it's been pointed out, the actual holding didn't reference that he was a bailee for hire, it just says because it's a bailment. And other cases have made clear that it is not required to be for hire, and that's not an issue in the certified question,
I'm
nor is
sorry
it
to
an issue
interrupt you.
preserved
Can I
here.
ask you about this? So it seems like the original cases proceeded from the premise that, you know, the core was an owner, and then the courts kind of analogized lessees, and then what you're calling an intermediate bailee. And essentially the rationale seemed to be that these people are all sort of in the same boat, and so we're not going to, you know, the liability should be similar. You fast forward now, and we have a statutory scheme that clearly doesn't treat these people the same in the sense that, you know, you have these caps for owners and such. How is it rational for us to, and I understand that you guys disagree as to whether we would be extending the, you know, the rule or preserving what you say is the well-established rule, but how would it be rational for us to continue on a path that sort of treats these similarly, what we thought were similarly situated people the same when, because of the statutory scheme, they no longer are?
Well, that would be because the entity who decides when there are certain public policies to treat otherwise similar people differently, that just depends on competing public policies. That's picking winners and losers. That's a legislative determination.
And so you're implying, I mean, are you implying that we should read the statute as implicitly having, quote unquote, decided that these distinctions are rational?
No, sir. The statute does not impose liability under the dangerous instrumentality doctrine. It limits it. Liability is imposed under the common law. The legislature, this court said, expressly adopted it by not rejecting it and instead creating exceptions. That was as early as the 1920s. And ever since, they've made 28 different determinations that we should cut this back in certain ways. Certain people, rental car companies, title owners, should have no liability or limited liability. But they have not chosen to do that for bailments. And if you're asking, is that a reasonable determination for the legislature to make, I'm not quite sure that's
Okay, but I mean, the other side of the coin is it reasonable for us? Are you saying that this is essentially that the court is sort of acting in a, that to the extent that there's this common law rule that came into existence as a court-created rule and that is continuing in existence because the court continues to apply it? I mean, are you saying that we should be oblivious to what's going on statutorily in terms of what we perceive to be kind of, a rational common law rule?
No, sir, I'm not saying that at all. And I would, the FJA's amicus brief speaks about the common law, and I think it makes some very good points that are different from changing a precedent under Poole. And the common law is designed for the courts to fill in the gaps where the legislature has not addressed a subject yet. But there are no gaps left. The legislature has addressed all the gaps that it saw fit. I mean, are there some unusual fact circumstances? Maybe we need that. But for here, this circumstance, there's been case law since the 1950s that has made clear there's intermittent Bailey liability. The legislature in any of these 28 amendments could have said, well, we shouldn't do that within families. That's what the second DCA, it didn't get rid of the doctrine. It said it's still fine just outside of the family context.
So it does seem like then a big part of your argument hinges on this idea that this type of liability that you're arguing for kind of well established and would have been known to the legislature.
Yes.
So that we can infer that their failure to address it is somehow, ratifying it or something. And it seems like there are significant, I understand sort of the labeling argument, but it seems like factually there's a big difference between an intermediate bailee who goes and rents a car in an arm's length commercial transaction as opposed to this situation where, you've got the one owner and then theoretically you could have all these different family members who are bailees. I mean, here the definition of bailee that was given to the jury is, very loose. So, can I ask, hold on.
Yes,
so it didn't seem like there was really much evidence of this principle as applied in this family context. You've got your dicta from Auerbach, and then you've got your different factual situation from the Frankel-Fleming cases. And then in between, I didn't see the well-established principle.
Well, Frankel said that as between the intermediate bailee and the person who's driving it, it is especially appropriate to put liability where it's not for hire, where it's between husband and wife. They said that it's especially appropriate. Now, it wasn't a traditional husband and wife.
But that business about the wife, that's very bizarre.
I understand. You're
because
right.
we know she wasn't his wife. She was a girlfriend. And but when you said about Frankel that it doesn't focus at all on, if I understood you correctly, on the fact that Frankel was a bailee for hire. I mean, I question that because when the court frames the question, it says one of the questions posed by the appellant seems to deserve an answer. And in that question, it makes specific reference to a bailee for hire.
Right, and then when it goes and
I
applies
understand
the
that.
law.
I understand that it doesn't repeat that. But that is the question they say they're going to answer. Isn't that true?
Yes, sir, that is absolutely true, and they were not actually husband and wife, so it is distinguishable from this case. My point is just the court said that made it more appropriate.
Just to be clear, though, the other major distinction that your briefs and that you're kind of eliding here is it's the comparison between, in our case here, the husband and wife and the creation of the intermediate bailment versus a rental car company and Mr. Frankel. And that's a clear difference. We don't need to get into whether the mistress should be construed as a wife or whatever. I mean, that's the more important comparison.
That's a clear distinction that the legislature has said, bailees for hire, we need rental car companies. We're going to immunize them from liability so that we can rent cars. In this instance, what we're dealing with is a family member who was in the position to decide whether the son should drive her car. He said, can I drive your car tonight? She said, yes, you can. She's the one who gave him control of the car. She had the legal right to do so.
But
by doing that,
this all turns on the fact that they had decided that the car would be titled in the husband's name and not jointly in the husband and wife's name. Because it had been jointly titled, if the wife's car had been titled in her name, then we would not be here.
You're
Isn't that
right.
correct?
Yes.
So you would concede that this is a little bit of an anomalous situation.
Not at
where-
all. This
where
is
the
very
wife,
common.
the wife is worse off because the car was not titled in her name.
She's worse off in that she doesn't get the cap. But by getting the cap, what you give to get the cap is your name on the dotted line that you're the defendant responsible. We didn't have that. Debbie didn't do that. We had to go to court and prove that she had the legal right to prevent this from happening. She is the person with the legal right who put the dangerous instrumentality in the hands of the negligent driver who hit a motorcycle. And so I think it's very different. This is a common scenario. And what typically happens is you don't want to title it in both parties, because if you do, then the joint marital assets can be seized on the judgment.
Can we ask
so
you
you
this?
split the title.
Just going back to basics just a bit, what is the purpose of vicarious liability involving a dangerous instrumentality?
I'm sorry, the purpose of?
The purpose of it. Why is it that we hold people liable for entrusting other people with a dangerous instrumentality? What is the reasoning?
Because they are the person who has control of something very dangerous, in this case an automobile. We want them to exercise the utmost care in deciding who is going to take it.
Right.
And it's so dangerous that we say that they are going to assume the liability of whoever they choose to entrust it to.
So if that is the purpose of it, and let's change. Let's take away. Let's not think about a car. Let's think about a dangerous instrument. Let's say a firearm, a handgun. You know, dad buys a handgun, gives it to mom because he's away all the time. He bought the gun. He's on the title. Gives it to her for protection at home.
Right.
Kid's going out one night. She says, "You better take this. You may need this," and something happens. Right? Isn't that the ideal situation to apply the vicarious liability?
Absolutely. I mean,
because
I think in this instance,
the person who actually had possession of the gun,
right,
who was most knowledgeable as to who's going to get the gun and what the conditions were that night and whatever, is the one that handed the firearm to the child to go out and to a party or whatever.
That's exactly correct. And one could make the opposite argument, perhaps embraced by the legislature, that merely holding title, you shouldn't be liable for everything. But when you're the person who doesn't have statutory cap, they haven't given a cap, and you're the person, you don't have title, you haven't put your name on, you haven't shown the world you're responsible for this car, yet you are in fact responsible for it, and you put it in the hands of a negligent driver, that's when the policies behind the dangerous instrumentality really kick in at their height. That's why there should be liability unless a policy decision is made, as the second district did here, that we have this intra-family dynamic that, oh, there's a policy, we should protect against that. And my first response to that is that's what the Auerbach case was, and this wasn't dicta. There were 3 theories of liability in Auerbach. The 4th district considered the liability of a non-title holding parent who allows a child to drive the car. The first theory was parental liability. You're just liable for the torts of your children. The 4th district says, no, you're not. And this court said, no, you're not as well. Unless there's a statute, if you sign a driver's license application, you are. So that's not a basis of liability. That's why we've never asserted that as a basis of liability. It is irrelevant to us that they're family members. That's their issue. The second was this concept of beneficial ownership, which there's been a lot of confusion that that's a theory of liability. Well, as this court has made clear, and so did the 4th district there, it's not a theory of liability, it's a defense from liability for the title owner to say, I'm not liable because somebody else has beneficial title. So that can't be a basis for imposing liability. That's why we've never asserted that as a basis. They keep saying we're talking about beneficial ownership, but we are not. We're talking about bailment. And this court approved both of those, and we didn't do anything about that. What we pursued was the third ground that the 4th DCA said that there should be an exception within the family because of the fuzzy dynamics. Well, this court did not agree, and it was not dicta.
It was, sir. I mean, with all due respect, I mean, the Fourth DCA, the bailment issue was not an issue in the case. The fourth DCA explicitly said this person isn't a bailee. Then our court just kind of gratuitously at the end of the opinion said, oh, by the way, you know, if there's a bailment interest, but that was never litigated. It was never an issue in the case. And so the holding of Auerbach here was just to, you know, affirm the result of the fourth DCA's decision that, you know, essentially rejecting this beneficial ownership stemming from the control of the car. And one of the problems that I have is that essentially, as I think as the other side points out, it would be very strange for us to to come to the conclusion that it wouldn't make sense to hold the parent liable in the Auerbach case, essentially just based on, you know, their access to the car and controlling the car and all that. And then
control of the car.
And then to turn around and say here that, you know, because of the magic word bailment, that all of a sudden we would, you know, allow the liability.
I don't believe you're reading this court's opinion correctly in two regards. First off, it wasn't dicta, and it was a disputed issue necessary for this court to even have jurisdiction. To have jurisdiction, this court had to conclude there was conflict, and it concluded there was conflict with the Frankel case. Now, this court might say, well, maybe that's not too direct, but it was unanimous at that point.
Well,
the holding in this court was that the holding in the trial court, or the district court, conflicted with Frankel.
I think it's being, I mean, I understand that you need to assume that the court properly found jurisdiction. There was no conflict with Frankel, and in Auerbach it said to the extent that it could be to the extent that the fourth DCA's opinion could be construed as. So I think even the court itself, by the time it looked at it, it implicitly recognized that there was no conflict.
Discharge jurisdiction. That was the basis for it to issue an opinion, and it did issue an opinion. And the opinion held, it approved the first 2 points, but it said the fourth district seems to be suggesting, exactly as the second district has now held, that another reason for letting the father off the hook, so an alternative ground for ruling on this basis to let the father off the hook, is that there was no bailment. This court said, or was because they were family members, and this court said, no, your first 2 reasons support this, but your third reason does not support it, and here's why. And so just because there's 3 alternative bases, each of which were addressed, does not render 2 of them dicta and only 1 a holding. The holding was that the father wasn't liable. The 3 reasons were there's no parental liability, there's no beneficial interest liability, and there is, contrary to what the fourth district says, bailment liability available, but it wasn't proven in this case. So for reasons different than the fourth district, we agree there's no bailment liability.
Well, I don't understand how that's not dicta, because it's about a hypothetical case,
right,
where it was proven. And it seems to me to be a hypothetical. The court's dealing with a hypothetical. I'm not saying it's wrong.
It's an alternative ground. Anytime you have an alternative ground, you could make that statement. What the court said is there are 3 bases from the fourth district. We approve of 2, we disapprove of the third, the reasoning, and that's a holding. And the holding was, contrary to what the fourth district says, bailment liability is available in the family. But it got the right result because it hasn't been proven in this case.
But counsel, the fourth DCA opinion, in this case, Louis Galena was not an owner, bailee, or lessee. I mean, and then there was no...
I know they said that, and then they also said...
Excuse me.
Yes.
There was no analysis in our case that was going into whether the fourth DCA was right to say that he wasn't a bailee, that we just made this gratuitous pronouncement at the end about bailment liability, but we never said what it would... We never said what it would take to establish that in a family context, much less apply it in the case.
Well, what you said was it says there's no different rule in the family context. And
Counsel,
what the fourth district, respectfully, you're
Counsel,
overlooking...
you're in your rebuttal time. You used most of it. We helped you, admittedly. I will give you 3 additional minutes, but the clock's going.
Thank you. You're respectfully overlooking the passage that the second district cited from Auerbach 1 and that this court was responding to in Auerbach 2, which was the passage in the fourth DCA's opinion that said the fuzzy dynamics among family members make this an inappropriate place to apply the dangerous instrumentality law. That's in there. They had both bases. They said there isn't evidence, and even if there was Because there was evidence, there was a jury finding that he had control. And this court said that was not bailment control, that's control just as the parent. That's not sufficient. But this court made clear that it is sufficient if there's proof of a bailment. That's been clear since the 1950s. And whether it was dicta or not, the legislature can read all this. It was as clear, it was as dead on to this case as saying, if you can't prove bailment, then the 4th District was wrong because that gets you liability. And that's what we've done here. And the legislature could make the policy decision to immunize family members, but there's great reasons not to. I talked about already, by putting your name on the title, you prove to the world, you alleviate the burden of the plaintiff to prove ownership. We had to prove that she had a bailment interest. And this isn't pitting family members against family members. Mother doesn't avoid liability by shifting liability to father or vice versa. This is not pitting anybody else at all. It's putting us to the burden of proving that somebody who's not even on the title nonetheless had an ownership interest, a bailment interest, and we did that.
And I hope the Chief doesn't mind me asking one more question. We're making, you're asking us to make what I think, for in terms of the ordinary lives of people, a pretty big decision based on this bailment issue, and I'm curious if the jury instruction that was given here on bailment is a correct statement of the law. I mean, is this all it takes? It's, the instruction was, a bailee of a vehicle is one to whom the vehicle has been furnished or delivered by its owner for a particular purpose with the understanding that it will be returned. You're acting like this is some, you've overcome some huge hurdle by proving a bailment. It seems to me that if that's the correct test, then every married couple and their kids and their in-laws and whatever, could be bailee. So I'm just curious, and I know we're not here to decide the law of bailment, but is this an accurate statement of the law?
I believe it is, yes. And it can't be in every instance. It has to be where one person is entrusted with control of the vehicle and uses that control to give to somebody else. That doesn't happen all the time. We're advised you put the title in the name of the spouse who's going to drive the car. And then they can be very careful about who else they allow to use the car. Here, that didn't happen. And the whole point of bailment liability, of dangerous instrumentality liability, is the person who has the legal control of the vehicle is going to be responsible. This kid, Kyle, if he'd let his friend drive the vehicle, said, here, Mom gave me her car, you drive it, and the friend causes a crash. Well, he's going to be liable as an intermediate bailee too, because he's the person who was entrusted the vehicle. He gets to make the decision of who else drives the car, and if he makes that decision to allow a negligent person to drive the car, he's going to be responsible.
Counsel, we've already gone 2 minutes over. I'm going to give you 2 additional minutes for rebuttal.
Okay, thank you very much.
Morning, Chief Justice Kennedy, Justices, and may it please the Court. Sarah Lalu Amin on behalf of the respondents, the Lamberts. Like all common law, the dangerous instrumentality doctrine has developed incrementally over time, largely by decisions from this court. But this next step in that development that Petitioner asks this court to make is an unworkable one for 2 reasons. One, it's incongruent with a century of law carefully developed by Florida's appellate courts. And 2, it would thwart the resolution of auto accident cases to such a degree, from creating uncertainty pre-suit about who could possibly be liable, through messy discovery that pits families against each other, and it does, prying into their personal information all the way, through messy trials within trials on these issues, on questions of use and permission that, as Judge Lucas put it, may be so loose and vacillating as to be indiscernible.
I understand the import of those jurisprudential policy concerns, but I wonder if first you could address what the effect is of the legislature's action in this space. That is, having capped liability for title owners of a vehicle. Is it fair to say that the action in that space would be nonsensical or rendered irrational if that cap also didn't operate to shield from liability an inter-family bailee? Is that your position?
Our position is that's precisely why you don't have these vicarious liability instances arising from intra-family bailees. And so when the legislature enacted that provision in that statute back in 1999, it did so against the backdrop of vicarious liability for the owner primarily. And then in addition, for bailees for hire, as Chief Justice Kennedy, as you noted, bailees for hire in the lessor-lessee context. That's addressed as well in the statute. What's not addressed in the case law or in the statute, because it has not been contemplated until...
What do you make of your opponent's argument, though, that in general, from legislative silence, what we take is an awareness of the common law, such as it was at the time of the legislative action in question, and a decision to only abrogate or fill some of the common law space. Can you respond to that argument?
Yes, thank you, Your Honor. And the answer to that is twofold. First, we are in the state of Florida where dangerous instrumentality is the backdrop. By virtue of Southern cotton oil 100 years ago, it's become a fabric of our common law. And so that's the backdrop against which we operate. And so now it's up to the legislature, and this is very different than it is in most states. Now it's up to the legislature to carve out from that liability limitations and so forth. And what this really gets down to, the second part, is the notion that it's been clear to everyone all along that clients like mine, like Debbie Lambert, would be liable here in a household. And I think what would be especially helpful, if the court could indulge me, I think it's helpful to consider all of the instances, all of the foreseeable defendants who could be held liable. And so if the court would indulge me for a moment, I'd like to offer a hypothetical, if I may. So, and I'd submit that this is not uncommon in many households in Florida. So mom or dad or both have title to multiple cars, and they have 2 kids who live with them, adult children, like here, like in Arbach. And these 2 adult children have permission to use all the cars, but this car is primarily for Jack, and he takes it to work. And this car is primarily for Jane, and she drives it to school. Well, one day, Jack's car breaks down, and he says, Jane, can I use your car? And she says yes, and he goes and he gets in an accident. The entire family gets sued. And who's liable? Under the petitioner's theory, if that were adopted by this court, now you would have one parent or both, depending on whether they're both title owners, and in addition, you would have Jane. She would be liable as well. The sister would be liable as well. So what we're promoting here with a policy like that is to look at everyone in that household. Look at everyone who had control, so to speak.
I get it. I guess my question to you is, going back to my statutory question, is so what? Isn't that the choice that the statute reflects? Doesn't the statute say that the only person who gets the cap is the title owner? Isn't that a legislative choice entitled to some discretion by this court? I guess that's the argument that I'm asking you to respond to.
Thank you, Your Honor, and I'll try to be more precise with that. And I'd respond as Judge Lucas put it, it's because the legislature has seen this all along the same way that we do, and that's how Judge Lucas put it below. And it really does come back to this question of, did anyone fathom that someone like Debbie in the same household could be liable? And that's why we don't see it there. So to answer your question as precisely as I can, it was not a choice by the legislature, and Justice, that would not be rational for them to do that. That would not make any sense.
What makes this so different than historically is the cap, right? The cap for ownership, if you have the title, then the legislature has said you have a cap now for the first time. When did that statute get changed?
That was amended in 1999, Your Honor, to provide for the cap for owners who are natural persons. And there were also limitations and limitations for lessees and so forth. And then we have the Graves Amendment. So every time the dangerous instrumentality doctrine is applying to a clear category of folks, and that's really what this comes down to today, is setting forth a clear standard, because this is a common law doctrine, and the common law should be clear. So it's not a problem for the legislature to handle because the doctrine itself is fuzzy. That is the work of this court.
Let me go back and just philosophically talk about some basic things. First, the nature of our role is to essentially get the law right, correct?
Yes, Your Honor.
But only as limited to the specific cases that are brought before us. We can't go try to get the law right in another area when it's not the cases before us. So you agree with that?
I agree with that.
And then I want to talk about precedent and the nature of precedent. So when we're talking about statutory or constitutional law issues, our approach, trying to get it right, is what is the law? Correct?
Correct.
Okay. And so it's a strict legal analysis. We said this in this case, this was the rationale, is that a correct interpretation of the statute, that kind of thing. I mean, but we're trying to get it right in that context. Here we're in the common law arena. And how does getting it right differ in the common law arena than it does when we're talking about an issue that's controlled by statute or the Constitution, a Constitution?
Well, and I think that that's unique to Florida as well because of the nature of this doctrine that's so unique.
No, I'm just talking about in general.
Sure. How is that different? I mean, in common law,
So a case comes before us. This is not, we're just trying to, fix the law, fix the common law. The case is before us, and we're trying to get it right. And if we apply the traditional legal analysis, what does our case law say, and just answer what the law has been and how that makes sense today, it seems like we could get a very bad result on a policy basis, correct?
Your Honor, I suppose that depends upon how the court construes its precedent in Arbach and as
I'm talking about generally.
Sure.
Generally, yeah. So you recognize we do have a policy-making role here, correct?
Absolutely.
And if an issue is presented to what is the law here, isn't the right answer to look at not only our precedent and what underlies our precedent, the legal concepts, but to look at the current legal landscape and current practical landscape?
Absolutely.
Okay. So an answer might be that a bailee today should be treated like an owner. I mean, would that be a legitimate common law answer to the question of what's the right answer here?
Perhaps it would, Your Honor, and that's something worth considering. At the end of the day, and that is why we framed the question broadly as we did, that to the extent she could be considered a bailee, she is not the type of bailee that's not the type of bailment that gives rise to dangerous instrumentality liability under Florida law. And so how we get there, it certainly could be by stating it must be an owner. And that's really what the legislature has done, is tried to kind of dig out the definition of owner and accept some entities from that ownership.
Well, let me ask you this, counsel. Have we ever said that when the legislature acts within the realm of common law doctrine and they address a particular issue, that somehow that freezes the common law and it's not subject to further development as the common law ordinarily would be through the judicial process?
Not at all, Your Honor. That's not what the court has done. If the legislature has acted in a realm and has taken over that realm, but this was the court's to begin with. This was a common law doctrine to begin with. This is the legal landscape, is the development of this doctrine through largely this court's precedent. And so to defer, it's really a misnomer to suggest that anyone would be deferring to the legislature at this point on the scope of this liability, because what the legislature's task is in the dangerous instrumentality realm is to then carve out. And that's, and again, as I think it's been noted here, there is a kind of philosophical dispute perhaps. Is this an expansion or is it a limitation? And it is absolutely an expansion to hold clients like mine within the same household liable when the owner does not disclaim liability. And that's very important here. And so in that regard, I think it's important to consider why we're here. What is the problem that needs to be fixed? It's not that plaintiffs don't have recourse. They absolutely do. The driver is always fully liable, and the intent of Southern Cotton Oil is accomplished. The title owner, the one charged with legal responsibility for the vehicle, is also liable vicariously up to the statutory limit. There's no problem that needs solving, by adding another layer, an unlimited layer of vicarious liability within the same family and the same household. Being placed on a judgment, especially a multi-million-dollar judgment like Debbie Lambert here, is a crushing financial obligation, and I do think it's important that we consider how this can be expanded to other potential defendants and what's going to happen in that regard, what these cases are going to start looking like, because this is just the beginning. If this court were to go this route, this is just the beginning. This came up, it was argued on legal grounds, but if this is the case pre-suit, it'll be impossible to settle these cases.
So you're suggesting that family members in the same household, right? That's the exception. So if it's an ex-husband not in the same, who has legal title, not in the same household, then liability would lie to the mom who's in the house.
Let me make sure I understand that hypothetical correctly, Your Honor.
Sure.
So if it's an ex-husband, you said, who's in a different household.
Right, but he has the title.
He has title, and she has the vehicle.
She has the vehicle, loans it to the kid inside the house.
And Your Honor, that's a different question. Certainly, that's a
Is
different
she liable
question.
under
Yes.
okay.
Yes. And so when we are talking about a family and we're talking, so then there's a question perhaps of whether there, at some point you get into questions, is it family? But the beauty of the standard that is offered by Judge Lucas here is that we almost never will need to ask those questions, because unless the title owner is disputing liability, we don't go around looking to add chains to the vicarious liability story to make other people in the same family liable. And so arguably, depending on the standard that's set by this court, if the title owner father didn't disclaim his own vicarious liability, then perhaps the mother wouldn't. And that's all dependent upon the scope of the answer that this court provides.
You objected at trial to the jury being instructed on the matter of vicarious liability by way of bailment. Is it your position before this court, or indeed in adopting the rule that you propose is wise, to say that no bailment was created here because indeed both these people gave the consent to Kyle to use this car, and in any event, the nature of the relationship here, the nature of the usage of this particular chattel, is not a bailment in the way that, say, a rental car transaction is a bailment? Is it your position that indeed there was no bailment?
Your Honor, I think it's fair. I think it's fair to say there wasn't a bailment. But as was noted earlier, this definition, this is the standard jury instruction, and it is very broad.
I get that, but I guess it matters because I think as Justice Muniz was asking earlier, if but for the incantation of that special word we're not here today, then I think it makes us think hard and want your views on what it takes to create a bailment in the context of shared chattel in a family. What more from your, I guess this is my question, what more would have had to have happened in order for a bailment to have been created in this case?
Thanks for that. In this context, it would be where the dad disputes the vicarious liability and says that was basically a theft or conversion, a species of theft or conversion, which is where this does come up. And so the only times that we typically see this are when the vicariously liable owner disclaims that vicarious liability, saying, I never gave permission for this. And so we've seen that in some of the cases, and the cases that the petitioner relies upon are all those cases. They're those cases where you can't get the owner, and the owner says, I am not the one who gave permission. And I think that's interesting, because what the petitioner is arguing is that mom was the one who gave permission, when the record's very clear they both did. The record's very clear that entrustment and permission, as those considerations are legally analyzed, was given by both parents. And so the focus, I don't think there's a way to do it, Justice, is the answer to your question. And I just don't think it's a workable concept within a family. Certainly among spouses who live in the same household, and it's going to change all the time. So by the time you've taken a statement before lawsuit, and now you're at deposition, the facts have already changed. The families...
Counsel, I'm sorry to interrupt you. So if we are persuaded that Frankel was about bailment for hire and that there really hasn't been an extension of it, previously. And if we say essentially that as between the husband and the wife, or I can't remember who was the title owner, but if there's no bailment created there in the first place, then does it matter whether the person to whom the car is loaned is also, the third person here, whether they're actually in the family or not? I mean, because it seems like the Judge Lucas test here sort of bakes that into the test, but it seems like if we agree that there wasn't a bailment in the first place, if the intermediate part didn't happen, then why should it matter whether it's a family member?
I think that I think that's an important question, because that is something that this court will necessarily have to decide, whether to keep it broad and really focused on the alleged bailor and the bailee, here dad to mom, or whether we're also going to analyze that third person as what happened in Frankel, where the focus kind of gets misplaced and everyone's looking at that third person, the driver, who was the girlfriend of the person who rented the vehicle. And so it is important to consider that. And I think that the simplest test that gives Floridians the most clarity, that gives judges the most clarity and litigants, is to focus on the initial relationship. Focus on the owner and the bailee. And really, as I think Judge Lucas framed the certified question, that's really where it ends. But if you were to keep it within a family, in terms of a family member's use of the vehicle being that third person in the chain there, if the court were to do that, I think that would be an absolutely, reasonable kind of tailoring this case to the facts of this case. But ultimately, the threshold question, as it's framed, should be when the vicariously liable owner disclaims liability. And so when you have that admission, we don't even need to get into those complicated questions, because that perhaps is where you would get into questions of, well, was this person family? And then you have to get into the business of defining family. And so
Counsel,
yes.
Let's say that happens. Let's say the owner says, no, I didn't give permission. Maybe it's the ex-husband. And so now there is this vicariously liable intermediate bailee. Should that person's damages be capped similar to the statutory cap for the title owner, because they're essentially kind of stepping into their shoes? Or is that then just sort of open for any amount of damages?
If that rule were set clearly by this court, Your Honor, that would be, I would concede, that would be a matter for the legislature. I don't think that this court can extend a statutory cap and by placing someone else in that category. However, if the court were to redefine owner in this context, then that could work, right? So I think that it's just dependent upon how the court approaches the solution to this problem. I think that the one presented in the certified question is a very reasonable solution, a very rational solution, that in the vast majority of cases will be fair to both sides, plaintiff and defendant. And so if the court, I see my time has expired, if the court has no further questions, we'd respectfully request that the court answer the certified question in the negative and approve the decision of the Second District. Thank you.
Rebuttal.
Just real quick on the facts. The facts were that the father said anyone in the family can drive it subject to what mom says, because it's mom's car. The night of the accident, Dad wasn't even there. Mom was there. He said, Mom, can I drive your car? She said yes. He drove it and he hit a motorcycle. As for the need for clarity, even if it's dicta, Justice Muniz, anybody reading what this court said in Auerbach 2 or what the Second District said in Stanford knew what the rule of law was, or at least what the court said it was.
Well, no, but that's a huge, it would be nuts for us to set a precedent that says that in addition to, making these inferences about what the legislature considered about the actual law, which is, a tall order, we're also going to assume that the legislature was aware of our dicta, treated that as law, and then legislated accordingly.
I think that's a good point, but I think you need to understand that dicta is a little bit different when we're talking about common law. When this court is announcing a rule for how the citizens of Florida will govern themselves, it's announcing a rule. It's prospective almost always, so if we're going to change things, they should be prospective. But more importantly...
Well, we don't, most often, obviously we sometimes have done that. that we announce the prospective rules. But that is not the ordinary course.
Oh, sure.
We decide that ordinarily, we decide a case, and even when the common law gets changed, it's changed in the case before us.
Right.
Isn't
Well,
that right?
like in the Hoffman case, this court had a whole set of dicta about, okay, we've announced a change in the rule. We're going from contributory fault to comparative fault. And these are the kinds of cases this is going to apply to. It will apply to cases where this was raised before. There's a whole litany of things. And that's when, because that's when the court changes the common law, makes an exception to a rule it is established. It's creating a rule of law that people need to govern their conduct
But
by.
isn't that the point? The rules are not established in dicta.
Well, they shouldn't be, but when this court, and that's exactly why this court should not change the law in an area where the legislature has occupied the space.
Well, but let me
Because it's
go back
lawmaking.
on that, counsel. It can't be your position that the common law is frozen whenever the legislature acts in that broad area at all. I mean, that just would seem to be an odd limitation on judicial authority in a common law area.
I would say there's a spectrum. And this court has gone up and down on the spectrum. On one end of the spectrum is tremendous judicial lawmaking, where this court can change the common law. You can have like a committee meeting, like it seems like we have on the policies here, and this court can decide what the law should be, and then that's a lawmaking function. On the other end of the spectrum are judges who say judges shouldn't be making laws. We should just be interpreting the law. And the legislature should make the law, and we should just sit back and do that. And I think where this court is on that spectrum right now is, yes, we've had the authority to do that, but we question our legitimacy the more we're making law and creating regulations and doing things, because we're not elected to do that. And the better role for us, even if we have the power, is to show the restraint, to say, okay, well, we've established a pretty broad rule of liability here. These people say, here's a good reason to limit that. Well, take that to the legislature, because they can look at, when you change the law, when you create regulations, there's all kinds of unforeseen circumstances. There's winners and losers. How is that going to impact a whole industry? How is this going to impact the insurance industry, which already factors in, whether it's dicta or not, when the Supreme Court says this is the rule of law, grants review based on conflict for the sole purpose of saying this is the rule of law, people change their conduct to follow it. And if you just keep changing all that...
Yeah, I've let you go over quite a bit here, but sum it up in about 13
Well, I would just
30
say,
seconds.
I would just say this court should continue to depart from the traditional role this court has had of being a lawmaking body. Sometimes you're going to have to answer a common law question where there's a true gap, but otherwise you should leave it to the legislature to decide when to contract or expand a rule of liability that this court has set in words printed for everybody to read, for all of us to decide how we title our cars, how we insure our cars, etc. It should not be upset based on the policy preferences of whoever's in office at any given time. We ask that you answer the question in the affirmative and quash the decision below.
Right, thank you. We thank you both for your arguments in this case today. That's the final case on today's docket, so the court will now stand in recess.
All rise.